withdrawn for silly mistake, Lordship. Can it be tomorrow, Lordship? AB. I have withdrawn on previous day, Lordship. Motion, Lordship.
Tomorrow, two things are there. One, so first up, I'll not be here. One thing. Second, most really is farewell reference will be there. So it may not be possible day after tomorrow.
May I please your Lordship? It's a bail matter. NDPS 22C read with 29. The main accused has been given bail. When I'm praying for listing.
You make a mention before the court number. 21.
Oh,
Make a
21.
mention.
Much okay.
May please your lordship. My lord, I pray for lordship indulgence to take up the matter, bail matter, as an unlisted today, my lord, if possible, my lord. To maybe taken up.
Which
as
item? Which number?
My lord.
Item number?
No, my lord. We have filed it unlisted. Unlisted.
Maybe day after tomorrow.
Tomorrow.
Day after tomorrow. Tomorrow may not be possible because division bench is there.
My lord.
Also, back to mention item number 24, Lordship.
Item number?
24. It is not available. 24. 24, my lord, case is not receiving.
24, what is the position? AB was.
Yes, on AB. I am on interim. Lord.
You are on interim. CD not available.
It is not receiving.
CD not received. Issue reminder. Interim be continued till next date of listing. Yes, list.
13-8.
1-3.
1-3.
I beg to mention item number 23.
23.
The case study has not been received.
23 CD not.
CD not received. Are you on interim?
Yes, Lordship, we are in time.
Same order, however. Yes, when it can be fixed?
My lord, on 19th of August.
Your interim will be extended till lunchtime.
Much obliged.
Wait, please, your lordship. Lordship, I beg to mention item number 32, lordship. In this case, I'm on interim, lordship. Case study probably is not there, lordship. May I pray for lordship?
32.
Yes, lordship.
Yes, bought a CD not
This is a
received.
CD not received. Ma'am.
Same order. When it
Interim
can be
may
fixed,
On
interim will be
18-8, my lord.
sorry.
18-8.
18-8.
Yes.
Interim may continue.
Interim will be continued till next date of listing.
Highly obliged.
There is a anticipated bail application may be taken on day after tomorrow, Motion matter.
Monday. AB will be Monday.
My lord, note, my lord, he is a my lord practicing advocate, my lord. My lord, may
What to
be
do?
taken on item.
Monday. It will be Monday.
No, please, your lordship. May I mention item number 20 and 21, my lord. I may I pray that same may be taken up on 24th of July, my lord, Thursday.
Yes, what about 2021?
CD received, my lord, otherwise case there is.
Are you on interim there?
I am on interim, my lord, on Thursday, 24th.
Thursday, lots of matters have been already posted in 24 both matters. 24 may not be possible.
29th, my lord,
20?
29th,
Okay. Both the matters?
both the matters.
Are you are in interim?
Interim.
Same order of interim to continue for. Both the matters, CD received, CD be retained till next date of listing. 29.
29. Repeat that.
May I please, lordship? Lordship, question of fresh AB matter, lordship, day after tomorrow.
Day after tomorrow, not possible. Monday. AB is Monday only.
All right.
Yeah, please, your lordship.
Lordship, item number 25 to 28, my lord. Arising out of the same FIR, my lord. Last occasion
25 and 28.
25 to 28, my lord.
All 25 to 28.
Yes.
Acha.
25 to 28.
Huh.
My lord, last occasion CD was there.
Yes.
But as it was before the vacation, my lord, therefore probably CD was returned, my lord.
Was there
Today
any
the
order
CD is not there, my lord. So
order retaining of CD was there or no?
no,
Not
it
there.
was directed to be returned, my lord. Because it was on the eve of the my lord, vacation.
After that, the direction was for up-to-date case diary.
Okay.
Okay. So, my lord, may I pray?
Are you on interim there?
Yes, we are on protection, my lord. Can it be
In
on
5 from 25 to 28.
Yes.
You are on interim, no?
Yes.
Yes.
Can it be on
CD
23rd?
up to date CD not received. Issue reminder. Yes, when?
On 23rd, my lord. It is from the Dispur only, my lord.
No, if you are on interim, it will be. I think it will be from month of August only.
Yes.
If you are on interim.
Yes.
Okay.
My lord,
Yes.
let it be in the second week of August. First week I may not be here.
Oh, it's the second week of August. Second week of August, kitne pa start is. 11/8 will be.
Yes.
All the matters on 11/8?
Yes.
Me please, your lordship.
Much of the
11/8.
May it please your lordship. Lordship, I beg to mention item number 41 of the daily list. Lordship, the petitioner who was suffering from leukemia, lordship, he had died, lordship. So,
Died?
lordship,
Oh, that matter.
yes, lordship. Lordship, this matter has become infructuous now, lordship.
Oh, but he was outside, I think. He was under treatment, I
He
think.
was under treatment, lordship. He had died on 23rd of June,
Have you
lordship.
anything? Have you?
Lordship, I have a discharge certificate.
Oh, he ultimately he died.
He died, lordship.
Oh. Haricharan, no?
Yes, lordship.
No, this is the only discharge, but you have the instructions.
Instructions we have, lordship.
As per your instruction, when he died?
Lordship, on 23rd, lordship, he had expired, 23rd June. It is written here, lordship,
Oh,
and
well.
expired on 23rd.
Oh, yes, yes. 23rd of June, no? In Tripura only. Okay, then. You are Mr.
On behalf of SK Das, lordship.
41, heard Mr. A. Koshal appearing on behalf of Mr. S.K. Das. And also heard Ms. N. Kakoti, the learned counsel, appearing on behalf of the standing counsel, Mr. Kyle, S.C. Kyle. It is submitted by Mr. Koshal that the petitioner was on interim bill, but during during dependency of this present interlocutory application, the applicant Haricharan Biswas died on 23rd of June 2025 in Tripura during his treatment, as he was suffering from leukemia. In view of this, the present petition has become infructuous and disposed of.
Obliged, lordship.
To keep with the case record, huh? Please with case record.
May I plead,
Number to
lordship?
deed of case number to Monday. Non Puluja board. Item number 41.
May I plead, lordship? I beg to mention item number 10. Speaks for TCR.
Item number
Yeah.
10, TCR we have received. Yes, anything?
It may be fixed on another day. Because Engaged Council is out of station.
Who is your engaged counsel? Laskar?
A.H. Lashkar. I'm not Hussain. So a short date may be given
The
you.
request made by the learned counsel appearing on behalf of Mr. A.H. Laskar, the engaged counsel for the petitioner. Matter is adjourned. We have received here when it can be fixed.
Yes. Copy receipt.
Scan copy receipt. Is it a what kind of matter this is?
My lord.
Is NDPS case or what?
Not NDPS decorative.
Dacoity.
Oh, yes.
Otherwise, charge sheeted case, na, he is in behind the bar. When it can be fixed then? Maybe can it be on the month of August?
Yes.
First week of August? Okay. What week, first week of August?
It's
5th or 6th? 5th of August.
Much obliged.
May I please, your lordship. May I please, your lordship, I recommend item number 37, lordship. Lordship, today engaged counsel Mr. LR Molnar is out of the session, lordship.
LR Mujumdar is not available. What is the position here? What happened?
Is there not received?
Are you on interim there?
No.
You are not on interim. At a request made by the learned counsel for the petition. Case is adjourned, and in the same time, it is also submitted by Mr. Bortapu that C did not received. Issue reminder, list the matter accordingly when it can be
My
listed.
lord, 31/7.
31/7. List on 31/7.
Okay.
I'd like to mention for listing of an anticipatory bail application. Can it be fixed on Monday?
We have already 3 matters have been fixed on Monday. Monday, again, some problem may be there because court may rise a bit early because of this oath taking. Let it be on Tuesday.
Obliged.
May it please your lordship. Lordship, I beg to mention item 16.
1/6.
1/6.
Yes,
CD not received. CD has not been received.
CD not received.
Lordship, could it be on the 31st of July? B.
It has to come from which district, in fact?
Bongaigaon. BA.
BA, Bongaigaon. If it can be done 31st.
Or 31.
31st. Issue reminder for you, CD not received 31st.
Maybe Lordship, back to mention item number 5, my lord, or today's list, my lord. The matter may be adjourned for the day, my lord. My senior is not available today. Can it be fixed on Monday, my lord? Yes, I leave it to your lordship, my lord.
No, not Monday exactly, maybe on Tuesday or Wednesday. Wednesday. Because Monday there are some difficulty.
Then Tuesday, if a lordship.
Tuesday also some of the matter has been fixed. I let it be on Wednesday. It's a AB, I think.
AB, my lord.
Okay, AB done Wednesday. Wednesday, 23rd of
Wednesday.
Yes.
Highly ordered.
Please, your lordship.
Item number 11. Request of midnight video. 23rd of June.
Hello, item number bail hearing, item number 11, Milord. In this, I cancel that the CD is not available today. And connecting matters, Milord, that is, Milord, on fixed on 22/7/25 per scan copy. So may I pray, Milord, this matter, maybe per.
Please just tell us the other number, AB
Yes,
number,
Milord.
BA number.
BA number 2151 of 2025.
No, 21.
51.
Here, your number is 2115.
Yes.
Another one, 2151.
51. 2025 fixed on 22 this month, 22nd, Milord.
Okay. CD not received, list the matter accordingly, list the matter along with BA number 2151/2025 on 22,
Yes.
22/07/2020.
Take long. Take it.
Awesome. Item number 1.
Yes.
Yeah, Ladat Kuti was directed to obtain a research whether any cases registered against the
Your lordship may kindly fix it at 2, my lord. I will get the instruction. At 2, my lord.
At 2. At 2. Tomorrow.
Only that instruction he will.
Yes.
Okay, then tomorrow. List tomorrow is what the date? Tomorrow is 17. List on 17. Okay.
Item 2.
Anticipatory bail application, my lord. There are two cases. There is a cost case, my lord. I'm applying bail on support PS case number 85. My lord, is a clash between brothers of the same family, my lord. They are cousin brothers are one side and other side the other cousin brothers. Your lordship kindly see, my lord. FIR, my lord. Page 18 is the vernacular, my lord. I translated it, my lord. Your lordship will. And it, page 12, my lord. Page 12, where I sought for bail, my lord. Page 12. My lord. These
Yes.
are all, my lord, our brothers. There are 7 accused, my lord. 1 lady. Lady has all. Now other 6 are before your lordship. 1 to 6 are before your lordship. It is most respectfully stated that today on 29/5/2025 at 10 AM, fire named accused persons came to the in group with stick, dao, and dagger, entered in the house of the complainant unauthorizedly and beaten up my family. Mention no man thereby grievously injured, grievous injury. Yes, in this it is to be mentioned here that the above named accused person hit Sattar Ali with dagger, which resulting in the grievous injury. The injuries were injured persons were immediately taken to Bongaigaon Civil Hospital, not Lower Assam. That is typing mistake. Bongaigaon Civil Hospital, where it is fighting for his death. As such, Your Honor is requested to conduct a appropriate investigation in the matter and take the legal action against the dean. So that is the FIR, my lord. That is your lordship kindly see that register, my lord, as a 85 support PS case number 85 of 2025 under section so and so. Only, my lord, that 109. That is, my lord, attempt to murder. That is, my lord, otherwise, my lord, all are, my lord, that can be granted bill by the police also, my lord. Now, my lord, your lordship kindly see the cross FIR, my lord, because our FIR, which was filed by us, my lord, it was one earlier, my lord. But your lordship kindly see that page, my lord, page 31, my lord. page 31. Has your lordship got it? Page 31,
Hmm.
my lord. Page 31. That is, my lord, at Zahirul Islam, that Zahirul Islam is the complainant of the earlier case, my lord. Earlier case. Here is the accused, my lord. It most respectfully stated that today at 28/5/2025 around 2:30 p.m. one person named Somas Al-Sabad Ali or Santosh Ali attacked and beaten up the group of by above named accused person after an argument regarding the trying of a cow. Today on 29/5/2005 at around 10 a.m. along with the local village headman visited the house of the above named accused person to confirm regarding the cause of action of the Santosh Ali, discuss the matter. Immediately thereafter, the mentioned accused person refused to discuss the matter and they threatened us. Immediately the accused person forced and fenced the paddy field. Thereafter, we broke the bamboo fence by paddy field and which was forced to accused persons, as a result of which the accused person in a group beaten up with a grievously injured Bilal Hussain, Samar Ali, Asidul Haq, Sohidul Haq and Kedar Ali with bamboo stick. Even though they 4 injured persons were to the support hospital by themselves and performing medical statement upon saying the critical nature of the injury sustained by the Bilal Hussain. So Ali doctors, after providing preliminary treatment, referred them to the Bongaigaon Civil Hospital for better treatment. So accordingly, this case is registered, my lord. Your lordship kindly see the same time these are both the FIR was lodged. And these are both, my lord, your lordship kindly see where I sought for bail. That is, my lord, annex up to page 12, my lord. If there is no specific allegation against anyone, my lord, there is no ingredient of section, my lord, 109. So even then, my lord, your lordship kindly see the FIR which was filed by us. It is against the counter attack, my lord. This FIR has been lost, my lord. So that's why I'm submitting, my lord. Your lordship kindly call for a case diary and they try to solve it by amicably by village mail also. Because all are cousin brothers, because they tie a cow in their land. That is the only cause, my lord. So, my lord, in fact, my lord, the annex B, this is a series I have annexed, my lord. That is by injured by all the person of my side of the injured, my lord. I have annexed all the injury report, my lord. So my submission before your lordship kindly call for the case diary, and your lordship kindly protect, my lord, because we'll give the real picture before the police, my lord, because my lord 307-109 is there, my lord. That's why, my lord, we are not granted bail by the police. In our case, my lord, because all, my lord, although there is a grievous injury, because it is admitted position, we got grievous injury, but they were granted bail by the police, my lord. So my submission before your lordship, it said there is a cross case and there is no specific allegation against anyone, my lord. This general statement, my lord. There is no ingredient of section 109, my lord. So that's why I'm submitting, my lord. Your lordship kindly call for the case day and will be protected, my lord. Yes.
My lord, here in this case, my lord, from the FIR, it reflects there are 7 accused persons, my lord. Out of which, my lord, accused number 7, Mozina Begum, was already granted anticipatory bail by the trial court, my lord. Page 38 is the order of the learned trial court.
I have an
Yes, from the page 38, it reflects why the anticipatory bill was rejected in respect of the present petition, my lord. Last paragraph, my lord. Last above, one injured subtly as admitted to Lower Assam Hospital, Bongaigaon, and Stoke. The statement of the witnesses and the injury report of the injured shows that the accused persons assaulted the informant and his family members, as a result of which injured sustained grievous injury. Though learned counsel submitted that there is a cross case, but the same is not enough to give so accused petitioner, except accused petitioner number 7, Morzina Begum, as it is shown in the case diary that on the earliest day of the incident, she attended her school at 8:44 a.m. as seen in the artificial intelligence generated teacher and staff report. The involvement of accused petitioner 7, Morzina Begum, is therefore prima facie. So on that ground, my lord, accused number 7 was granted, but finding materials,
my lord, I from that I'll explain, my lord. Then very good, my lord. He has read this out. From this, my lord, there's only one injured person. Only injured person. That is, my lord, they says, my lord, all are getting injured, my lord, in the affair, my lord. And from your lordship, kindly see one that's they says that all the 7 persons were present. But from this finding, that petitioner number, that is accused number 7, the Margina, he was in the school at that point of time. So that prima facie goes to show that their FIR which is filed by this is the counter to our case, my lord. From that finding, my lord, it is clear, my lord. Because it is clear finding that at that point of time, Margina was in school. Then why they have stated in the FIR that, my lord, she, along with her name was there, she also come to attack them, my lord. So that's why I'm submitting, my lord. So that was not, if I also, my lord, your lordship go by their finding, my lord, there is only one injured person, my lord. They said that the all family had been injured, my lord. But from the finding of the learned district judge, session judge, my lord, that is, my lord, only one injured person. That is my submission, my lord.
Mr. T. J. Monto, the learned senior advocate, assisted by Mr. R. Bora, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Mohanto, the learned senior advocate, that the present accused petitioners and the informant side are the relatives and the cousin brothers. It is a fact that there was a dispute between the two groups for
tying a cow in their land.
tying a cow in their land, and for that the the present petitioner who lost the FIR
My lord, present.
from your side, Villa.
Our side, my lord, it was lost by my lord, Sahinur. Yes, from our side it is Sohid Ali, a nephew of the, my lord, petitioner's, my lord.
No, from your petitioner side, who lost the FIR?
From petitioner side, my lord, petitioner's nephew lost that.
Acha. So for that incident, one of the relative of the present petitioners lost in FIR. And the present FIR is also a counterblast of the FIR lost by the present petitioners. However, no, petitioners, full stop. It further submitted that only that there is no clear allegation against, there is no specific allegations against the present petitioner as to how or who assaulted the informant side, and thus the informant side, though case is registered under section 61 subsection 2 to 329(4), 1182 and 109 BNS. However, all the petitioners are ready and willing to cooperate the IO in further investigation of this case if they are granted with the privilege of interim pre-arrest bail. Next, Mr. Botaku, the learned additional PP submitted in this request that from the FIR and the order filed by the learned court below reveals that the present petitioners are involved in the alleged offense of assaulting the informant and his family members. And accordingly, he submitted that the actual fact will reveal only after perusal of the case diary. Next, madam. Considering this submission made by learned counsel for both sides, all the aspects of the case, I find it a fit case to extend the privilege of interim pre-arrest bail to the present petitioners till receipt of the case diary. Okay, you'll be under interim protection. Appear before the IO within 7 days, cooperate and investigation. CD
21/8.
21.
8.
Deputy.
Item 3,
3 and 4 my lord, out of same FIR, my lord.
3 and 4.
Lawsuit.
Four to
FIR, my lord,
ekalage
page 9 my lord.
4 to ekalage DD. 3.
4 didiye. Item 3 my lord, where the brother and sister and our elder sister was got married, my lord, with the son of the informant. About 8 years back, they have 2 minor children, my lord. He committed suicide. Then, my lord, FIR file, my lord, page 9. Allegation against the wife only. Married, my lord. The humble submission is that on 26/5/2025, about 12 o'clock at night, my daughter-in-law, namely so-and-so, came to my door and informed that my son so-and-so is serious. Then I immediately got up and saw that my son Rahul Amin is dead. Then I asked the accused number one how my son died. Then she replied that my son committed suicide by hanging. It mentioned that the accused number one so-and-so, so-and-so. And accused number 2 and 3, my lord, were brother and sister living in different village. Sister also got married, my lord, in different village. They have named, but there is no allegation against them. Just name has been incorporated. We will cooperate, my lord, with the investigation, my lord, these two petitioners, my lord. And regarding wife, my lord, case diary may be called for, my lord, and postmortem report may be called for.
Case of murder, my lord, 1031. Then the case diary may come on that day, my lord, if there is no material against the
Regard,
present
in the FI itself,
Only
there is
after-
nothing, my lord.
only after perusing the
Only
case diary
wife has been involved,
from the
according
FIR,
to
it
FIR.
cannot be said, my lord, that these persons are not at all
An
involved.
incident took place at 12 o'clock in the room, my lord. How they
But as they have been
lost?
incorporated as a accused person.
Just name has been incorporated.
I
There is
don't
nothing,
know,
no
better to
allegation.
call for a case diary, I
Ye-
think, because maybe a murder also.
My lord, we are the brother and sister, my lord.
Maybe brother and sister, how you are involved,
Yes,
that is not known to us, why your name has been there.
Not
Mention in there.
the FIR.
Otherwise, if from the FIR, obviously, there is no at all mention about.
We'll
in
cover
the case
regarding
of-
wife,
case
my
of-
lord,
case of
regarding
103, so.
regarding wife, my lord, your lordship may call for case diary.
no,
and
both
other
the
two
matters,
things
city
lost.
cooperative, city call. When it can be called for?
7th of August. Or 12th of August, 12.
7th of August will do,
Lost.
7th of August. City.
Okay.
That I same order.
In 6.
Motion or the motion in nine. Up to the motion.
6, my lord, CD not received. me.
Subject motion is in nine.
Maybe your lordship. This is second time bill application, your lordship. It was AB, your lordship.
Earlier it was rejected, I think.
Rejected, your lordship.
So in that case, if CD is not available,
Yes.
then definitely will be one day.
With prayer, you know, short date may be fixed, your lordship.
It's brought up and it can,
On my lord, 13/8, my lord.
13/8 will do or what?
On then 7/8, my lord.
7/8?
7/8.
7/8. List on 7/8, issue reminder.
Item 7.
Yes, Mr.
No, please, I don't know, 7, kindly after some time, my lord.
Item 7.
Yes,
You have
please.
received this can copy?
Please can copy, yes. Yes.
Okay, time being.
Item 8.
May I please, your lordship?
Yes.
Lordship, the allegation is under section
Okay, you have
82.
received the case diary
Yes,
here.
case diary received, my lord. And today also, my lord, FSL report not yet received regarding, my lord, cause of death, my lord, case of dowry death, my lord. Postmortem report is not conclusive regarding cause of death, my lord. So earlier FSL report was called for, my lord. Today also FSL report. Yes, sir.
Otherwise, what was
Yes,
the
on the-
nature of injury, anything was there in the PM? report?
Yes, my lord, I will point out. And earlier also, my lord, here, there is allegation of, my lord, there are materials against the accused party regarding demand of dowry, my lord. And here the victim committed, victim was died on 2/5/25. There, before that, my lord, one injury report is available, my lord, regarding physical and mental torture. One injury report is also available in the case diary. Before the incident, my lord, they assaulted, and a report regarding petitioner was assaulted by the, my lord, petitioner. And in that case, my lord, petitioner was a report. From the report, it reflects that my lord, deceased person was injured, and that report is available in the.
May I please, Your Lordship? Lordship, this is a case under section 82 of the BNSS, dowry debt. Now, Lordship, as on date, I am behind the bar for almost 75 long days, Lordship. Now, the PM report, postmortem report says that the cause of death is inconclusive. In that case also, Lordship, it is not a case that there is more than one accused person. There is only one accused person, that is the husband of the deceased. Now, it is a fact, Lordship, that on the date of the incident, the husband of the deceased was a Difu, Karbi Anglong, working as an electrician. And regarding that, Lordship, I have annexer number 6, page number 31, 32.
How can you say
He
it is
voted-
an admitted fact?
Sorry, it's
Who is
it
admitting
a
in
fact,
that?
Lordship. So I beg pardon, Lordship.
So as per you, he was a different.
Yes, yes. And I have annexed a train ticket at page number 31, 32. Immediately he got the news of the unfortunate news. He came down, he boarded a train, he came to Guwahati, he went to the morgue, he prayed for the dead body of the deceased to be for the last rite to be held at Guwahati, but the police did not allow him. So this is the fact, Lord. When regarding the informant is not the parent of the deceased. He is projected as one of the uncle. The parents of the deceased, they do not have any issue. They never had any issue with the petitioner. The only issue was that the informant, he used to always instigate the deceased, that the petitioner, he is not a rich person. He will never be able to keep the deceased happy. And regarding this, there was an issue between the altercation of words between the deceased wife and the petitioner, Lordship. The deceased asked the petitioner to go to Difu for working as an electrician, saying that the income over there is better. But the petitioner says that he does not want to work in Difu. Regarding this, there was like altercation of word. Apart from that, Lordship, now what has been submitted that in the year 2024, there is some kind of report. Now regarding that, I have made a statement, Lordship, may kindly be pleased to see para number 7. The petitioner himself, he dropped the deceased to her matrimonial maiden house. He went to drop the petitioner. The report that is being talked about in the year 2024, months before the incident, that is a complete different incident, Lordship. On 27/10/24, at para number 7, Lordship, may kindly see, there was a religious ceremony. The petitioner himself dropped the deceased to her maiden house. He came back. He do not have any knowledge about any such incident. Now, from where this report has come, this is not known, Lordship, because there was no any such incident. The only incident that happened was a few altercation of words over phone. The deceased wanted to stay in Guwahati. The petitioner wanted to stay in Guwahati. The deceased asked him to stay in Difu, to work in Difu, because the income over there is good. And the informant, who is a distant uncle now, he has come up with all these allegations. And Lordship, may kindly see the length of detention, Lordship. As of now, I am already near about 75 days. I have a minor son now. The mother has already expired, unfortunately. She has committed suicide. So now I being the father, I am behind the bar for 75 long days. I have a 2-year-old son to look after, and there is no one to look after him. My parents are looking after him. They are also in a very bad state because of this incident also.
My lord, these are the submissions of the petitioner. Otherwise, there are, my lord, materials against the present. Within 7 years of marriage, my lord, this incident occurred. And my lord, there are, my lord, evidences which reflect the petitioner physically and mentally harassed the, my lord, deceased. And because of that, earlier he left the house of her husband. And during that period, why? Because the present petitioner, my lord, physically assaulted, and for which she left the house of the my lord, present petitioner. And thereafter, immediately, my lord, she admitted in the hospital. And then, my lord, this injury report is there in the.
Lordship, that is the incident of 2024.
Yes, my lord, because
this incident is of April.
since earlier, my lord,
2025.
this person is involved in my lord, harassing the deceased, my lord. And because of his my lord, harassment, my lord, she left the house of her husband, my lord. And demand of dowry, my lord, regarding that aspect also, my lord.
There may be some kind of matrimonial issues, Lordship. I do not deny that. But projecting the case to be not a case of suicide may not be right, Lordship.
Without getting any report, it cannot be said.
His parent statement is also here? No, not recorded.
Parents' statement, I will point.
The parents never had any issue, Lordship. They were very happy with their son-in-law. This is the informant. He always had a grudge upon the petitioner. And he is the main person who always used to instigate both the families, saying this and that. Para 10, I have stated lordship. Since 21st of April, 2025, the petitioner was working at Difu Karbi Angan. And on the date of the alleged incident, the petitioner was not even present in Guwahati, lordship. And there is no any other accused also in this case. He is the sole accused, being the husband.
But Waterpool, he may not be present at that time because two witnesses have stated that he was not present when the incident had happened. When
At that point of
she
time,
committed,
at that point of time, he may not be present, but my lord,
otherwise
there
you
are
are saying that.
evidences that he, my lord, earlier also, my lord, continuously the harassment of and demand regarding that. Anyway, because FSL report also not yet received, my lord, earlier.
His younger brother is not an accused.
No, only one accused, lordship, the husband, that is the petitioner.
You are Mr.
M. Ahmed.
Heard Mr. M. Ahmed, the learned counsel for the petition, and also heard Mr. P. Waterpool, the learned additional party, appearing on behalf of state respondent. This is an application, the section so and so in connection with so and so. CD receipt, where of the same. It is submitted by Mr. Ahmed that the present accused petitioner is innocent and he has not committed any such offense as alleged against him. It is a fact that there was some dispute between the present petitioner and the deceased, as the deceased, as he did not want to work in, as he was willing to stay at Guwahati, but on the pressure created by the deceased, he had to leave for Difu as an electrician to work as an electrician for electrician, electrician post. But on the day of incident also he was not present in his house, and getting the news of the unfortunate news of his wife, immediately came to Guwahati, and then only he came to know about the committing suicide by the wife deceased. Posto. He further submitted that accused is in custody since last 75 days, and hence, considering his length of detention also, he may be released on bail. However, he is ready and willing to cooperate with IO in further investigation of this case if he is granted with the privilege of bail. Next point, Mr. Bhattakur, the learned additional PP submitted in this report that there are sufficient intimating materials against the present accused petitioner who also used to torture the deceased mentally and physically, for which she even had to leave her matrimonial house in the year 2024 for the torture 24. One injury report is also available in the case diary. Further, he submitted that till date the FSL report is not yet received, but from the receipt to know the actual cause of the death of the deceased. For full stop. So he further submitted that considering the incriminating materials against the present petitioner, his bail prayer may not be considered at this stage. Next paragraph. Hearing this submission made by learned counsel proposers, I have also perused the case diary and the medical report of the victim, though the cause of death is yet to be ascertained due to yet to be ascertained as the FSL report could not be collected by the IO till date. However, considering the materials available in the case diary, length of detention already undergone by the accused petitioner, I find that further custodial interrogation of the present accused petitioner may not be necessary for the interest of the investigation. And accordingly, I find it a fit case to extend the privilege of bail to the subject condition did you apply. This is cases from which place?
Dispute case. Dispute case.
CGM Kamrup Metro.
Yes, sir.
To the satisfaction of the CGM Kamrup Metro. Okay, you'll be granted bail.
5 days, 71 days.
71 days.
No.
Why misleading?
For 2 days, he was in police custody. For 2 days.
He got arrested on when?
He got arrested on 3rd. On 4th, he was forwarded for the first time. He was given to police custody for 2 days. Therefore, from 6th, he was again in judicial custody.
75 days, including the police remand. Including 2 days police. That will including 2 days police remand.
Deeply obliged, Lordship.
Oh.
And being item 7.
Law for help we have already. Item 7.
Lordship, and here this case regular bail application, Lordship, already charge sheet has been submitted and 274 days in custody as on today, Lordship. And Lordship, the petitioner name is not in the FIR, Lordship, and subsequently only 800 rupees transaction is made in the informants are trained, Lordship. And I'm coming to page number, Lordship, and FIR 21, Lordship. FIR.
Before going into the meat of the case, Lordship, or text of the case, Lordship, there is a last order, Lordship, and kindly peruse. As per last order, Lordship, there was a report was called for from the court below. Whether there is the section 47 notice was given or not, it has to be verified from the records, because as per the observation of the Honorable Court, that there may be some, as it was sent through scanning, so some paper may be left up, so that has to be verified. Therefore, that I have taken steps, and that report is not yet received, Lordship.
But Lordship and others, I have the certified copy and obtained from the court below, Lordship. These are the certified copy.
No, but the question is that you may have a certified copy, but the order is that he has to verify it. But why is report is not here?
Lordship, report, no, I have not received the report yet, Lordship.
Not yet. Otherwise, we can have peruse your this certified copy.
Lordship.
But the question is that as the court directed the learned APP to
Lordship.
give the or to brought the report, then when it can be fixed?
On Tuesday next or Wednesday, any day, Lordship. Okay.
The second Lordship, others 275 days in custody. Their name is not in the FIR also, Lordship. But subsequently they have been incorporated.
It is a charge sheeted case.
Lordship.
Under which section? Charge sheeted.
103 and one Lordship.
103 is a murder.
Lordship, but murder is not Lordship, suicide Lordship.
Suicide.
Suicide. The FIR itself is very clear Lordship. And
No, but the charge sheet is under section of earlier 306 or 302.
earlier 302, but right now Lordship 103 Lordship.
Right now 103 means I cannot follow you.
Lordship.
Right now, how 103?
Lordship actually should not be, but the IO has submitted charge sheet. But
Oh,
because-
it is your
Lordship.
submission.
Lordship.
Oh, I thought that
But it
there
is
is an
103 Lordship murder.
otherwise murder.
Lordship, others.
May not be
section-
murder or whatever, but
Exactly,
the
exactly.
question is that is charge sheeted as a murder case.
Lordship.
Let the report be come also thereafter also maybe.
Saturday.
Yes, tell us when it can be fixed.
Wednesday.
The report, who registry will bring the report or who?
I have taken steps to the OC concern.
Okay.
OC concern will go to the court
Ah.
below, and there's a peri officer, and he will verify the records that whether there is whether that notice is there or not.
That will verify by the IO.
No, sir, that court PP Lordship.
PP.
Lordship, others,
Please,
Lordship, page number 42 Lordship.
Just. Yes, it was I don't know, there was a complaint of 47 business. He submits that since the records are scanned and they sent, there is a possibility that some documents may have been left out in that process. I mean, that may not come also. Considering the nature of the impairment, matter stands adjourned today. The court is inclined to permit the learned DPP to make an inquiry with IO of the session case number 7, which is pending for adjudication before the. So at this stage, will it be possible to contact with the IO and take the verification report? I am just.
Yeah, I think that's a big.
How will you? I mean, how you want to initiate or how will?
And now there is a peri officer. Lordship. I don't know actually what is his.
PV?
Peri officer. One peri officer is there also. That is, and he will verify the court records also. In the court proceedings.
So you are going to receive the report from that officer.
Otherwise, Lordship, at this stage, Lordship, all the recording part of court Lordship. But yes, I see the same.
Acha, pay officer. So what step you have taken now, till now?
I have communicated the order to the OC concern, and he today I tried to contact with him, but I couldn't contact with him. So if the matter be decided again on Tuesday next, till then the OC may visit the office or to that concerned officer and may.
IO or OC? Who will be the person?
Sorry, OC.
OC. But here it is written as IO. IO may not be possible
IO
because it
because
cannot
that
say
they-
that IO is there
IO
possibly, yes.
Maybe different. Also,
Ah.
same person.
He already transferred, I think.
I have communicated to the OC.
Communicated to the OC.
Sorry, Lordship, one submission, Lordship.
Now it is just because of 47 notice, it brings some disaster for them also, Lordship, because if that ground is not taken, then the matter could be adjudicated
Without even, yes,
That-
obviously.
because of that, Lordship, nowadays it is.
Mm.
Lordship, sorry,
Earlier it was the easy
But
part.
now
not
the
easy
matter is in Supreme Court and there is an observation of the Supreme Court also, Honorable Supreme Court also.
part.
Regarding 47, there will be an order now. Because if the may not be the way the grounds of arrest may not be there, grounds of arrest may not be communicated, but if knowledge is there, then most probably it will be a bit, the coordinate benches of this court also have observed that, taken up that view. So 47 may not be that strength at present.
In Kasireddy case, Lordship, it is clearly stated, Lordship, that Lordship, when he knows and if he is being told, then also it is like
But Lordship, and I
Publicly Kasireddy.
Kasireddy, I have gone through the Kasireddy Lordship, but there is one thing is very clear. And the entire system, entire process, Lordship 22 and 21 is very clearly communicated to the accused person. And that is very much clear. And that is why that case was dismissed. But otherwise, the mandate provision is communicated. And Lordship, sorry, Lordship, and can I
Anyway,
come to page number 14?
Anyway, we won't.
10 Lordship, I'm sorry, Lordship, and 103 is not here, Lordship. Charge sheet is submitted 308 subsection 2 and 108 and 35, Lordship.
Acha,
So extortion is, Lordship.
acha. Not,
Not 103.
murder is
Murder
not
is
there.
not there, Lordship. So kindly for a moment, page number 40.
No, I'm not going to hear. If you cases adjourned Tuesday, then only. Because we are in a position now
Lordship.
because the coordinate bench of this court has already passed the order. So that is only aspect only. Otherwise, you could have hear with the matter, in fact. Anyway, heard Mr. F. Fogg, the learned 7, F. Fogg, the learned counsel for the petition, also heard Mr. B.S. Locker, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Locker that though he communicated with the IO, but report is not, OC of the concerned police station, but till date he could not collect the report in pursuant to order dated 25/06/2025 by this court. Mr. Locker accordingly submitted he needs some more time to obtain the report through concerned OC as well as the PAIRV officers if already appointed by the court. In view of this the matter accordingly. Tuesday, when you want?
Tuesday.
Tuesday is which one? 22nd.
22nd.
Okay, then 22nd. Realistic. How will see to it?
Deeply obliged.
Based on 22nd.
May I please have?
Yes.
This case, you see, NPS case, page 11 is there.
Before he starts, my lord, earlier rejected by your lordship, my lord, this case, my lord. So my prayer before your lordship, my lord, this matter may finally taken up day after tomorrow or my lord, at 2, my lord, I will have to get some instruction, my lord.
Already, you are in this case, 2 accused persons. Already 1 accused person, accused number 1, already you are granted bail
By whom?
by your lordship. I have annexed this order, page 20. And
Yes,
1 days
your lord
behind the
not
bar.
rejected, my
And
lord,
I
your
petition
lordship has
behavior 160 days. And your lordship order page 20. And your lordship's view is page 26, para 12. Considering that notice, page 20 is the order. And I am the accused number 2, and accused number was the honors of the courts, and he was released on bail by your lordship. I am the driver of the vehicle. He was hired my vehicle.
But the now 47 will be
Their
viewed
letter was
in
passed by
different way.
8/5/20-
That is why.
2021.
No, it will be viewed a bit different way.
Tomorrow, my lord.
Day after tomorrow, I don't know, Friday. পারিনে নোৱাৰিম তো। ডিবি কালি এটা আছে, কালি আছে ডিবি, পৰহি Friday ক'ব নোৱাৰো এতিয়ালৈকে। Tomorrow we are having DB in fact, Friday not yet decided.
Then at 2, my lord, I will have to.
At 2, your lordship. Today at 2.
Today at 2? Okay,
Yes,
today at 2.
my lord, I will have to.
Item number 12 and 15.
Okay. 12 and 13 are connected.
Connected, lordship.
What is the
Please,
position here? You have received the case.
Yes, case diary received, my lord.
Here in this case, Lordship, out of the same FIR, Lordship, some other cases are fixed tomorrow, Lordship. All the cases would be connected or should be the case? Who other cases are?
Case study received, my lord. Yeah.
Tomorrow, court in this court or which court? Court number?
21, Lordship.
Because why I'm saying tomorrow may not be possible before this court, because we have again, this division bench matter. So tomorrow may not be again possible. So we can do one thing. It is fixed tomorrow. We'll simply pass the order along with, okay?
Yes.
Then it may be taken up
Yes.
by court number 21 also. Just tell us the numbers.
AB number.
AB, these are AB, those are AB.
One BA is also there.
Acha, AB,
1567,
AB 1567.
1576.
Huh?
And Lordship, another two cases. Lordship, I'm
1,
giving.
2 AB.
3 AB, Lordship. Two
AB
other-
1567 and then
1576.
1576.
Another two cases, Lordship, I'm giving, Lordship.
These two are AB,
These two are AB.
along with another two cases.
Yes, Lordship.
Those are BA.
One BA, one AB.
The 3 AB, 1
Three
BA.
AB, one BA.
Acha.
I'm giving the number, Lordship,
Okay.
within 1 minute, Lordship.
And the request made by the learned counsels for in both the matter same submission. You are also appearing one.
13, Lordship.
You are appearing on 30.
Yes,
Same
Lordship.
same
Same
submission.
case, your lordship, but I am ready for doing this case because the case diary already received, your lordship.
No, there may be due to he is submitting that there are maybe the order may be same on parity, that is maybe one of the aspect. So better to fix it tomorrow along with the others. I think so it will be better. I think. So then the request made by the learned counsel for the petitioners, let the matter be listed along with AB 1567 of 2025, AB 1576 of 2025, and two others now.
I'm giving.
Arota Duta DSM. And list accordingly CDB retained. We're retaining the case diary.
Highly.
Obvious.
Item number 14 and 15.
My lord, 14 and 15, my lord. Maybe, my lord, 14, 15, can we take after some time, my lord? The seniors are lagging put over 11, my lord.
14 and 15.
14 and 15, my lord.
Okay.
10%, two cases, my lord.
Okay.
Obligation.
আপনার একটা ইনফরমেশন বেঞ্চত দিব 12 আর 31 যে প্ৰেয়াৰটো দিছিলে যাম সেইটোৰ লগতে দুটা এবি তিনিটা এবি আৰু এটা বিএ আছে এই 5টা 7টাকে যদি আমাৰ এই ধৰ আমাৰ প্ৰব্লেম হ'ব খালি ডিভিজন বেঞ্চ আছে প্লাছ আপোনাৰ ৰেফাৰেন্স আছে সো মেটাৰ মে নট ৰিচ আপুনি এবাৰ ইনফৰমেশ্যন দিব যে এইকেইটা আমাৰ দুটা মেটাৰ কোড নম্বৰ 21 যদি পাৰে আৰু মিলাই তাতে দিব দিছে নহ'লে মানে কি হ'ব আমাৰ তাত টাচ নকৰিব প্ৰব্লেম হৈ যাব CD আমি ৰিটেইন কৰিছোঁ সেইকেইটা মেটাৰ তেওঁলোকৰ তাতে কোৰ্টত 3টা 4টা মেটাৰ অলৰেডি ফিক্স আছে অহাকালিলৈকে তো এই দুটা মেটাৰ তাত দিলে হ'ল CD ৰিটেইন মানে আপুনি এবাৰ কমিউনিকেট কৰিব কাৰণ এইটো মেটাৰ আপুনি ইয়াত ৰিচ নকৰিব পাৰে কালি কিমান মেটাৰ এনে লিষ্টিং হৈছে আপোনাৰ
Item number 17.
May I please,
yes
my lord, in this case, my lord, CD was called for.
CD receipt.
My lord, petitioner before your lordship is a government employee, my lord.
Government employee.
Government employee, my lord, and his son, my lord, mobile was, my lord, handling minor son, my lord. And he shared, my lord, my lord, another, my lord, Facebook post, which was posted, my lord, by one unknown person, my lord.
Son or unknown person or whom you are blaming?
Unknown person posted, my lord, my lord, Facebook post, my lord. And that was, my lord, son, my lord, by mistake, my lord, it was, my lord, shared, my lord.
Liked and shared.
Shared option, my lord, he. Immediately thereafter, my lord, he, my lord, deleted, my lord. And it was happened, my lord, lordship, kindly will look page 12, my lord. It was happened on 9/5/2025, my lord.
Post was of 9/5.
9/5/2025, my lord. And according to my lord, informant, he is a public servant, my lord. He also, my lord, noticed, my lord, this Facebook post on that day, my lord. Page 12, my lord, this is FIR, my lord, 9/5/2025. I came across a shared post on Facebook from the account of name Mustafa Ahmed Loshkar and the profile link so and so, which contents that is deeply communal, inflammatory, and intended to provoke enmity between. Then the share post is included abusive, hateful language, making inflammatory statement, issuing threats, etc., my lord. And my lord, he lodged this FIR, my lord, on 4/6/2025, my lord. On apprehension that, my lord, it will create, my lord, communal, my lord, disharmony, my lord. After 1 month, my lord, and he was immediately arrested, my lord, without following due procedure of law, my lord. Forwarding report, my lord, in the next page 13, my lord. On the day of arrest, my lord, FIR he was lost, but in the next day, my lord, he was forwarded 5/6/2025, my lord. And his I-card is, my lord, page 15, my lord, annexure 3. Actually, my lord, unmindfully, my lord, it was happened, my lord, and immediately he deleted that post, my lord, but subsequently FIR, my lord. And he is in jail, my lord, since 5/6/2025, my lord.
Since 5/6.
Yes, my lord. In the lower court also, my lord, he submitted in this way, my lord, while bail was declined, my lord, page 17. Page 17, my lord, in the middle, my lord, from the bottom, second paragraph, it has been submitted by the engaged counsel for the accused that the accused is innocent and he did not share the alleged post. His minor son was having the mobile phone in his hands, and being a child, he did not know the contents of the post and mistakenly shared the same. When the accused person came to know about this, he immediately deleted the post, and he did not have any kind of intention to spread hatred and communal disharmony in the society. Accused person is a responsible citizen and he did not commit any such offense Therefore, he is to be released also. He is a government employee, my lord, prima facie, my lord, that can be, my lord, lordship. May we please to believe that, my lord, naturally, my lord, being a, my lord, he is above 40 years old, my lord, government servant, my lord, he would not have, my lord, shared this, my lord. So by mistake, my lord, it has happened, my lord. And he has suffered a lot, my lord, since 5/6/2025, my lord. And FIR was lodged also on apprehension, my lord, that maybe, my lord, cause, my lord, communal disharmony, my lord, but there is no, as per instruction, my lord, there is no, my lord, example that anything bad happened because of this post, my lord.
Well, as here we have received the case there, my lord. Although my learned friend transferred his burden to his child, my lord, but he himself admitted that he has shared the post, my lord, where it was, my lord, against, my lord, Prime Minister of India, my lord. Here it was seen that উক্ত ভিডিঅ'টোত আমাৰ দেশৰ সন্মানীয় প্ৰধানমন্ত্ৰী নৰেন্দ্ৰ মোদীক অসভ্য ভাষাৰে গালি গালাজ আৰু নানা ধৰণৰ ভয় ভাবুকি দিয়া ব্যক্তিয়ে ফেচবুকত আপলোড কৰিছে, my lord. He has shared it, my lord. But it is, my lord, and thereafter he has admitted, my lord, he has done this, my lord. This is the serious in offense, my lord, and against the Prime Minister of India, my lord, and he has shared this video, my lord, uploading against his, my lord. That's why it is not a case, my lord, for granting bail, my lord. And from the ground of arrest, my lord, it was also said that, my lord, my lord, video highly provocative and intended to incite hatred, dispute public order, and create fear among citizens, which can lead to serious public unrest, violates the law, and divert the attention from the involvement of Pakistani terrorist activities and directly supporting any enemy nation, my lord. He is supporting the, my lord, enemy nation, and when in the time of, my lord, we are praying, all the nations praying for the, my lord, Pahalgam incident, my lord. He has shared this video, my lord, in the social media, my lord. That's why we have gone to the, I have also gone to the case there, my lord. It is clearly, my lord, he has done this with the intention to create hatred among the people, my lord. This is there, my lord. It is not a case, my
It
lord.
is also there.
My lord?
Video or any?
Video, my lord.
Video.
Thereafter, he has deleted, my lord. Deleted the post, my lord. It is not a case of bail, my lord, at this stage, my lord. And investigation is also going on.
After, my lord, 1 month, my lord, it was FIR was lodged, my lord, and as per, my lord, allegation, on that day, my lord, 9/5/2025, he, my lord, gone across to this video, my lord. And after 1 month, FIR was lodged, my lord. Till date, my lord, nothing happened, my lord, only on apprehension. By mistake, my lord, only, my lord, if anything is shared, my
He is
lord.
the matured person, my lord. How he, by mistake, he shared the video, my lord, against the
And,
Prime
my
Minister of
lord,
India, my
he
lord.
has suffered a lot, my lord, and there is nothing, my lord, happened. Any unwarranted, my lord, things, my lord, as on today, my lord. After long back, it was shared, my lord. It is a government employee, my
My
lord,
lord,
about
here,
40.
section 183 of subsection 3 is also here, my lord. 113, my lord, subsection 3, my lord.
Only, my lord, police taken step, my lord, and he has suffered, my lord, and he will not want to take a lesson, my lord, and he will not do, my lord. He should be careful, my lord. But it is, my lord, apparently, my lord, it was by mistake.
Extended imprisonment for life, my lord.
Otherwise, my lord, no responsible person will, my lord, only share one thing, my lord. Something is telling, my lord, against our honorable Prime
But
Minister.
it was at the time of sensitive time, my
And
lord.
he has suffered a lot, my lord,
We are
comparing.
against their Pahalgam incident, my lord. But he has shared this video, my lord, against our country, my lord, and supporting the some other nation, my lord. That is our
Animation.
my lord.
And, my lord, in this case, my lord, also, my lord, arrest procedure are also not maintained, my lord. Illegal.
No, my
arrest
lord,
is
here
done.
all the, my lord, 47, 14 notices, sir, in the case there.
Only thing is that, my lord, only on apprehension, my lord, FIR was lodged, my lord. Belated FIR, my lord, and nothing happened, my lord, as one today, my lord. And he is admittedly, my lord, deleted, my lord. And he has also, my lord, admitted his guilt, my lord, that by mistake it was done.
Heard Mr. A.M. Bormiya, Dillonette, counsel for the petition. And also heard Mr. B. Sharma, the learned additional BP appearing on behalf of state respondent. This is an application on section so and so in connection with so and so. CD received, whereas received. It is submitted by Mr. Borgna that the present accused petitioner is innocent and he has not committed any such offense as alleged in the FI. However, it may be a fact that his minor son mistakenly had shared that objectionable video, which was posted in the Facebook, which was posted in the Facebook. Further, he submitted that the present accused petitioner is an government employee and is responsible person, and he never shared such video intentionally, and it was maybe a mistake on the part of his minor son. Mr. Borgia further submitted that as per the FIR, the informant came across the shared post of the Facebook account on 9/5/2025, but about 1 month later he lost the FIR to this court, and since 5/6/2025, after lodging of the FIR, the present petitioner got arrested in connection with this case. Thus, the I also got sufficient time, public opportunity to interrogate the accused petitioner, keeping him in custody. Mr. Borgna further submitted that the Facebook post was of 9/5/2025, but till date there is no such incident of any communal but till date there is no public unrest or the communal communal clashes between any groups, and till then, and it was only the apprehension of the informant, but informant full stop. He further submitted that after coming to know about the mistake done by his minor son, he immediately deleted the video and did not share it with any other full stop. The accused person is in custody since last 5/6/2025, and thus the IO got sufficient opportunity to interrogate him and repeat his custody. Interrogate him in keeping him in custody, and hence further custodial interrogation may not be necessary for the interest of the investigation. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next, Mr. Sharma, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present accused petitioner. Rather, he himself admitted that he had shared the objectionable video wherein the Honorable Prime Minister is also Prime Ministers also have been abused in the said video, and the said video was shared or posted when the entire country was when at the time of the Pahalgam incident, and supporting the enemy nation, which will create the public inside the hatred in the public in the public, and then there is also fear of creating serious public unrest in the country. And this post was shared, video post was shared only to divert the attention from the involvement of the terrorist activities by involvement of Pakistan, involvement of the terrorist activities of Pakistan at the Pahalgam incident. Accordingly, Mr. Sharma submitted that this is not at all a fit case to grant bail to the present accused petitioner at this stage, and investigation is still going on, and some other culprits are yet to be nabbed in connection with this case. Next para, considering the submission made by learned counsel for both sides, and also considering the materials available in the case diary and the objectionable and specifically the sharing of the objectionable Facebook post, this court is of opinion there that the further custodial interrogation of the present accused petitioner may be necessary for the interest of the investigation. In view of this, I do not find it a fit case to extend the privilege of bail to the present petitioner at this stage, and accordingly the same stands rejected. Your petition stands rejected. এটা মাতিব দে মই নাম উলিয়াইছো এটা মাতিব খালি
May I present also? My lord, with all respect, my lord, court has nowadays.
You are on 18?
My lord.
18?
18, my lord. 18, 19 together, my lord. But regarding 19, my lord, the accused was beaten up in custody. To that effect, my lord, a report was sought for by the learned citizen down below, my lord. With all respect, my lord. So 19 may not be taken up today, my lord. It might be taken up after a week, say, because that report would be very necessary, my lord, for seeking bail, my lord. Regarding 19.
Regarding 19.
Regarding 19, my lord. And regarding 18, my lord, I'll read the affair, my lord. Prior to that, the dispute is this, my lord. There is a plot of land, my lord. The person who is his custody, my lord, he is around 65 years of age. And what has happened, my lord, there is a land dispute between him and an industrialist, my lord. But first, I'll definitely read the affair, my lord. Prior to that, I come to an earlier 144 proceeding, my lord. Now my lord, the section of law is, my lord, the section of law is different, my lord. May your lordship turn to, my lord, with all respect, my lord, page 47, my lord. (47), my lord. May I read, my lord? This is, my lord, with all respect, my lord, earlier 144, now 163 BNSS, my lord. So both the parties were debarred entry into the said plot of land, my lord, by virtue of this order, my lord. The petitioner in that, my lord, with all respect, my lord, that 163 proceeding was Bijoy Kumar Jain, and the present accused, my lord, is Jagadish Kolita, my lord. Lordship has seen, my lord. They were debarred, my lord. So if somebody is debarred, my lord, earlier 144 violation is always there. If violation is there, my lord, 188, my lord, statutory provision is there, my lord. Now, my lord, that is in place of 188, now it is, my lord, with all respect, my lord, section 167 BNSS, my lord. May I just read it once, my lord? Then I'll come to the FI, my lord, with all respect, my lord. 167 BNSS. Local inquiry. My lord, may I? Yes.
Yes.
As regards violation of 163 BNSS, my lord, statutory provision is there, my lord. And now 167 of the BNSS states, my lord, whenever a local inquiry is necessary for the purpose of section 164, section 165, 166, my lord, the inclusive of definitely, my lord, 163, a district magistrate or a sub-divisional magistrate may depute any magistrate subordinate to him to make the inquiry. Here, my lord, now let me come to the FIR, my lord. How they have exceeded the law at the first instance, my lord. The FIR, my lord, with all respect, is at page 20, my lord.
Yes.
With reference to the above general entry, I am to understand, my lord, first paragraph is regarding, my lord, whatever it is there, my lord, not of much importance, my lord. Thereafter, my lord, second paragraph is very important, my lord. Today morning, first party Bijoy Kumar Jain, kindly see the language, my lord, made the Superintendent of Police, Nalbari, and informed that the second party has violated the Honorable Court's order. Have I made my position clear, my lord? That order I have read out, my lord. For that, recourse is there, my lord, in the code itself, my lord, with all respect, my lord. But instead of doing that, because of his hobnobbing with higher officials, my lord, he made the SP, my lord. And what the SP did, I'm not into that, my lord. Kindly see the illegalities committed by the investigating agency. Upon receiving this information, Superintendent of Police Nalbari directed me to investigate the matter. He was devoid of jurisdiction, my lord. When there is a violation of 163, my lord, with all respect, my lord, statutory provision is there, my lord. Instead of agitating that, my lord, you go to the SP. SP, my lord, being devoid of jurisdiction, still he directs the OC to conduct an investigation. This is not a case of to be investigated upon by police, but by the magistrate concerned, my lord, that to executive power, my lord. But anyway, my lord, I'm not on. Thereafter, my lord, kindly see how this old man has been put behind bars. Accordingly, SI Rupjyoti Kolita Wasai Juli visited the spot and asked second party Jagadish Koli to appear at the police station. I'm for Jagadish Kolita now, my lord. The father, 65 years of age, principal of a college, my lord. What has happened, my lord? He was brought to the police station. Rather, instead of calling him, my lord, anyway, my lord, if he was called, they were devoid of jurisdiction, my lord. In a case of violation of 163, my lord, he came, my lord. Now, what they write, shortly thereafter, Jagadish Kolita and son Gaurav Jagadish Kolita, my lord. Prime accused is Gaurav Jagadish Kolita, my lord. Came to the police station. At that time, while I was deciding my official duty in my office chamber, both criminally transferred into my office. I stopped here, my lord. You, my lord, summon me, first paragraph. When they appear, they say that you criminally trespass into the office. Have I made my position clear, my lord? My lord, dichotomy. And thereafter, my lord, upon questioning Sri Jagadish Kolita why he is violating the court order, he is devoid of jurisdiction, my lord. Court order, his son, this is wrong, my lord. His son Jagdish Kolita became furious and assaulted me and punched me in the face. It is regarding the son. My lord, he was subsequently beaten up. Medical report was sought for. So I have prayed that it be, my lord, postponed, my lord. After I let that medical report come, then his bail application may be considered, my lord. I am for the father now, my lord. And what is the role of the father? Causing grievous injury below my eye. My lord, that is also improbable, but not possible, my lord. The assault was carried on. The allegation against the present 65 years old man, my lord, carried out on the instigation of Jagadish Kolita, my lord. Can it happen, my lord? And let me place the other papers before your lordships, my lord. Thereafter, my lord, with all respect, my lord, yeah, page 20, my lord, page 24, page 21, the forwarding report I am reading out, my lord. His age is, my lord, 2, my lord. Lordship has found, my lord. Page 21, my lord. Jagadish Kolita, he is 64 years of age, my lord. Allegation against him that he instigated his son to punch the policeman, my lord. Have I made my question clear, my lord? So this much. And age is 64, apparent on face of the record, my lord. And thereafter, he fell down, my lord, with all respect, my lord. With all respect, my lord. May I come to page 43, my lord? Magisterial order, my lord. 42. I'm taking a minute, my lord. I'm sorry, my lord. My lord, page 43, that he is the principal of that junior college, my lord. To prove his, my lord, resume, my lord, with all respect, my lord. He is the principal. And my lord, with all respect, my lord. Page 47, my lord, I have read out that 147 order, my lord, with all respect, my lord. 144 CRPC order, my lord. And let me come to, my lord, page 54, my lord. after being, my lord, arrested on the charge of instigating his son to bash up, he felt, my lord, there was a seizure, my lord, there itself at the police station, because page 54, my lord. Seizure, my lord, lordship has seen, my lord. Seizure, my lord, Jagadish Kolita, with all respect, my lord. Jagadish, this is the situation, my lord.
When only, that day only.
That day only, my lord. 26/6. And why the entire incident, I never said that, my lord, arguing with a policeman is good. Despite if somebody is called, my lord, if the police officer is devoid of jurisdiction, definitely there should not be altercation or, my lord, with all respect, my lord, physical, any sort of activity, my lord. This is regarding the son, my lord. And son was so badly beaten up that, my lord, the ministerial order will show, that is that page, my lord, with all respect, my lord, page 23. 23, my lord. Parting lines, my lord. Lordship has 23. On the other hand, as per inspection memo, accused Gaurav Kolita, there is tenderness present on both wrist joint, over right shoulder joint, redness over left cheek. The said accused also stated that he got injury in his leg also. In this respect, on being asked, the said accused, Gaurav Jagadish Kolita has stated that he sustained the aforesaid injuries during the period of his stay at Nalbari police station yesterday, as some persons covering their faces, including OC Nalbari police station and other police personnel, have beaten him. In view of the above, as the allegations regarding, my lord, custodial violence, a report was sought for. That is why I am praying for postponement regarding the son, my lord, the prime accused. So let it come after a week, my lord. We will place that magisterial, my lord, the consequence of this magisterial order, my lord, and seek bail for the son, my lord. And regarding the father, my lord, he is there for 20 days. And these are the, my lord, 21 days, my lord. These are the materials before your lordships, my lord. So far as I am concerned, my lord. And section 45 cannot be attracted, my lord, because in the police station is there, my lord. If instigation is there, it has to fulfill the ingredients of section 45, my lord. Earlier 107, my lord, instigation. Then it has to be on camera proof that father must have said to the son that beat him up. Have I made my question clear, my lord? This is the situation, my lord.
Yes, Lord.
There was, yes, my lord, here there are two petitioners, one is son and one is the father, my lord. Here, my lord, main problem ultimately arises because of the assault of the, my lord, because by the son of the petitioner, my lord, to the OC of the Nalbari police station, my lord. Here I have an injury report, my lord, that from that injury report, it reflects that simple injury. And my lord, swelling in the left cheek, reddish in color, abrasion of size 2 into 1 cm in the left forearm, my lord, irregular blood. So these are the, my lord,
Injury of the police officer.
injury report of the police officer. And my lord, considering otherwise, my lord, considering the length of detention and age of the father of the petitioner, because allegation is mainly against the son of the, my lord, petitioner. So your lordship may, that part your lordship may consider regarding.
Lordship may fix it with all respect, my lord. Whatever order lordship passes regarding the father, my lord. Regarding the son, my lord, we'll provide the certified copy, my lord. Let it come up after 3-4 days, my lord. If possible, my lord.
80 to Kuritokson.
On a side, my
Hard Mr. B.K. Mahajan, and at the request of Learned Counsel, Mr. B.K. Mahajan for the petition. Matter may be listed next week, then it will be listed.
23rd, if possible, my lord.
24th.
How
24th.
about highly obliged.
19 or 8 to 19. Sorry, this one is for 19. 19 is 24/7. CDB written till next date of this day. CD receive query, CDB written till next date of this day. And other one.
18 million.
Heard Mr. B.K. Mahajan, the Learned Counsel for the petitioner. And also heard Mr. P. Bhattakur, the Learned Additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so poster. It is submitted by Mr. Mahajan that there was a
Keeping the peace.
There was a
163%.
163 proceeding between the present petitioner as a second party and one Mr. Vijay Kumar Jain as a first party, wherein the prohibitory order, there was a prohibitory order by prohibiting both the parties from entering into the disputed land, and the order was passed under section 163 of the BNSS. He further submitted that if there is any violation of 163 BNSS, the proper statutory provision to approach the court is under section 167 of the BNSS, but without following those procedure, the first party of the said the proceeding had approached the
SP, my lord.
Page 20. Approached the SP which state, which district?
Nalbari,
Approached the SP Nalbari, on which approached in Nalbari, alleging that the second party, that is the present petitioner and his son, has violated the prohibitory order passed by the London Bay Street. On that, both the present petitioner and his son was called by the police officer, and on police officer, and there was an allegation that while they appeared before the police station, and the time of discharging the duty by the informant oblique, he is the OC or who?
OC, my lord.
OC, officer in charge of Nalbari police station. At the instigation of the present petitioner, the son of the son had assaulted the police officer, but except the instigation of allegation of his instigation, there is no other allegation of assault on the police officer by the present petitioner. He further submitted that without resorting to the proper procedure of the law, the second party had approached the SP Nalbari, and without having any authority, he directed the parties to appear before the OC of the concerned police station. However, the present petitioner is in custody since last 21 days, and he is a 65 years old person.
64, my lord.
64 years old person, and also was discharging as a principal
Of a junior college, my lord.
of a junior college. He further submitted that considering his length of detention already undergone by the accused petitioner, further custodial interrogation may not be necessary for the interest of the investigation. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next, Mr. Botaku, the learned additional PP submitted in this regard that there's a clear allegation of instigation against the present petitioner, on which his son, the other co-accused, had assaulted the OC of the Nalbari police station, oblique the informant. And however, as per the medical report, the police officer sustained minor injuries due to assault of the other co-accused persons. Mr. Botaku accordingly submitted that his prayer for bail may not be considered at this stage. Next, considering the interest submission made by learned counsel for both sides, nature of allegation brought against the present petitioner, and other circumstances of this case, I find that further custodial interrogation of the present accused petitioner may not be necessary for the interest of the investigation. In view of this, whose satisfaction this is?
Nalbari, my lord. CGM
Nalbari. CGM Nalbari. Okay, CGM Nalbari, he is granted with bail.
Highly obliged, my lord. Obliged, my lord.
Supplementary counsel is bail hearing, item number 42. I made it. So this is
কিমান নম্বৰ কৈছে আপুনি supplementary? 42. To 40. No idea. And up to 42, key position আছে. It is a hearing. We have received the case diary here.
Is they received, madam?
It is received.
Is they?
No one appears. None appears on call for the petitioner. Hard Mr. P. Botapur. You are on just a second, 42?
40.
Okay. Yes, we have received the case diary here.
Yes, Lordship. Already 59 test, Lordship.
Kindly after some time, my lord, B. Sharma has gone through the case diary, madam.
No, it is a 60 days offense otherwise.
No, no, NDPS.
NDPS,
Also
21,
NDPS.
21B and
Oh,
29.
21B
Or
and-
21B.
Yes, Lordship.
Then you just ask him to take the only instructions and whether
Oh, yes. madam.
charge sheet is already
Yes,
been, just for timing. We'll
Timing.
take it.
Daily list, item number 22.
My lord, the lordship directed to appear with the copy of the order
22, my lord, case diary not received, madam.
on 9/6, my lord, he appeared. And I talked to him, my lord, his statement also recorded on 9/6.
9/6.
Yes.
I mean, after obtaining the interim.
We
You have not received the case diary. Case diary have received.
Madam, I will get the report, madam. I'll
So
get-
many times. Listed so many times, man.
He's already-
Interim is there.
The interim is there, but updated, you have not received the updated one, no?
Yes, ma'am. Already he interim, madam. Interim is there, madam.
Heard Mr. S. Chauhan, the learned counsel for the petitioner. Also heard Mr. P. Potapu, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Potapu that updated case diary is not yet received. In view of this, let a fresh reminder be issued, directing the IO to submit the updated case diary. List according.
On 19/8, madam.
19/8 video. Interim be continued till next date of listing. Your interim will be continued till next date of listing.
Item number 29 and 30.
No one is there. What is the position 29 and 30?
29 and 30, madam, CD not received, madam.
Are they in interim or no?
Hmm. Earlier also, my lord, none appeared in some occasions.
In AB 1070, which is a 1070. 1070 is item number 29. There on the last occasion, one Mr. FKR Ahmed had appeared.
Yes, ma'am.
Oh, another bail application, 114.
Yes, for during pendency. of the
Oh,
case,
acha,
ma'am.
acha, acha. এটা কি অর্ডার হতে তুমি অর্ডারটা কখন দেখতে 111144 নাকি This is the order on item number 29, in fact.
Oh, yes, ma'am, during pendency of the present. Oh, yes, my lord, during pendency of the case, my lord, the one another anticipated bail application filed by the same accused petitioners, and in that case, my lord, the petitioners are protected, my lord.
This is 30 is
this is-
1144.
This is order dated, yes, 1070, the
Hmm.
order dated 9/6/25.
Hmm.
And thereafter, the present order, your lordship, their names are struck off by order dated 25/6/25. Your lordship.
So
may kind-
initially, how many petitioners were there? In fact,
Initially, 6 petitioners, my lord.
out of 6, three names are already stuck up.
No, initially,
Name of
there-
3.
here 9 petitioners, my lord, in
9.
1070, 9 petitioners.
So out of 9, name of 3 already struck up.
Struck off.
So you are appearing on 30.
Your lordship.
It is a reduction 29 to Karpanam Katamisa 30 item to do. It to 30 নেই। Now 1144 there are
There are 3 petitioner, your lordship. Where in
in
the early
1144.
1144.
1144 3 petitioners.
And in the item 29, which the bail petition which have been filed,
Names of these petitioners were also there. They were
so
struck
there at
down.
that time.
Yes, yes.
But without, when we did not have any knowledge of that they have they have moved the petition earlier. So we were seeking for the striking out of the name. So earlier, on the last occasion, the name have been strike off from the item 29. So now these 3 accused in item 3, in the earlier petition, their name has been striked out.
Strike. Yes.
Yes.
So anyway, in item number 30, we have received a case diary.
Now 29 and 30 case diary not received.
Not received.
Not received.
You are on interim.
There are 3 accused, or 2 accused have been granted protection, and accused number 3 has not been granted protection, your lordship.
So 1 and 2 had already.
1 and 2. 1 and 2 is the mother and the father,
Ah.
and accused number 3 is the son of accused number 1 and 2, your lordship.
Hard MS. Your MS.
So, Madhuri, at this stage, lordship may kindly grant me protection, your lordship, where, as I have not filed the additional affidavit, but lordship may kindly go through this, where in the DC, in that district, they have filed one peace petition, your lordship, one application they have filed, the accused. The other page is the translated one, your lordship, where they have the accused have filed a petition seeking the complaint that the other accused, the complainant, they have been falsely implicating them in a wrong allegations and all, and they are disturbing their mental peace, your lordship. That have been written in the application.
Now, this application is filed by whom?
Filed by accused number 3, your lordship.
So alleging that these are the complainant and the others, they are disturbing.
In them regarding the piece of land, your lordship. The query is all about the piece of land only, your lordship.
But it was not considered earlier, so at this stage we are not going to consider. So simply heard so and so, the counsel for the petition. It is and also heard Mr. Botapu, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Botapu that the CD is not received. From the order dated 26/05/2025, it is seen that the accused petitioner number 1 and 2, 1 and 2 are already granted with interim protection. However, the prayer for interim protection of the respondent number, accused petitioner number 3 was not considered. Was not considered. When it can be listed, what about?
On 13/8, ma'am.
List the matter accordingly on 13/8/2025. Till then, till then, the interim order granted to the accused petition number 1 and 2 will be continued. List accordingly. Okay. Are you file for AB 29-2? None appears on call for the petitions. List the matter accordingly on 13/8/2025 along with AB number 1144 of 2025. Okay.
Obliged.
Finding item 42.
40?
After some time, my lord.
Nine what? Common one.
42. ma'am.
No. Prosecution has days. You
Yes.
have short some time.
After some time. my lord.
Yes.
Then 41.
31, yes.
My lord, this is anticipatory bail, my lord.
Hmm.
The petitioner,
Here we have received the case diary.
Yes, my lord, case they received, ma'am.
my lord, actually, 4 numbers.
You are
of
appealing
cases-
for informant.
Yes, Mr. Thank you.
Lordship.
In this case, the 4 members of bail petition has been pending. The other accused are there. That is today before honorable court number 21. So can it be taken up together, Milord, all this? Because earlier occasion, all the cases were listed together. Milord.
So in that case, in the for the other 3,
Yes,
when the date is fixed,
today.
how can we today we can transfer? Today is not possible.
And the other 3 cases has been listed before honorable court.
Yes.
Today itself. Any date, Milord. Or simply adjourn it, we shall take with all those other 3 matters.
But we have to retain the case diary.
Yes, Milord. Day after tomorrow, no problem.
No, we are not listing it on day after tomorrow. Maybe listed by see what date this dated, then we
Yes.
can send the case record because 3 are pending there only. So we'll find the list accordingly along with so and so. Along with so and so. Okay then. Heard Mr. A. Ali and also heard Mr. P. Potapu, Dilani Division PP, appearing on behalf of state respondent. Considering the submission of Mr. S. Sahu, appearing on behalf of the respondent number 2, oblique informant. Let the matter be listed. You just tell us the numbers.
1068. Milord, 1098,
1098,
1103,
1103,
1061.
1061. All are AB or all are AB. All are AB. So and so list the matter along with Likhisana. So and so. Till the date of listing, CDB retained. Okay then.
My lord, earlier interim order may continue.
Here one interim was
My-
there.
my-
Interim order we continue till next date of listing.
43.
Yes.
Here, Lordship, CD and the injury report was called for. Here, what has happened, there was an altercation. The allegation is this, that I have beaten up 2 persons in a festive occasion. But our allegation is this, that there was a counter blast. They came with a sword to attack us. When I tried to protect myself, they got the injury. No, the injury is simple injury or the injury is that my brother can say from the injury report only.
That's a medical legal report, not received also. But his some prescriptions are there also. He has been treated as outdoor patient also. On the same day, he has been discharged. And his statement also may kindly fail also that
মই পৰি যাওঁ আৰু উঠিব লাষ্ট পাৰ্ট তাৰপিছত ৰূপমে আগবাঢ়ি আহি মোক চৰ ঘোচা মাৰে মই পৰি যাওঁ আৰু উঠিব নোৱাৰা হওঁ তাৰপিছত তপনে মোৰ বুকুৰ ওপৰত বহি মোক মানে মাৰে তাৰ হাতত চোকা অস্ত্ৰ আছিল হয়তো কাৰণ মোৰ মুখৰ ভিতৰত চিলাই পৰে আৰু মোৰ চকু দুটা বেয়াকৈ আঘাতপ্ৰাপ্ত হয় সেই সময়ত সিহঁতৰ বন্ধু গৌতম দাস আৰু ৰাকেশ আহি মেধিৰ ওচৰতে আছিল তাৰপিছত মই বিহুজ হোৱা যেন হওঁ আৰু পিছত মোক ওচৰৰ ঘৰৰ মানুহে হস্পিটেলত ভৰ্তি কৰে
Let the injury report come, Lordship. It comes from the last time because I'm not on interim. I'm praying that I should be at least give some interim so that I can give my statement.
because I think there is no such because
From where you're saying that on the same day he was discharged, was there any advice?
not sim there is one medical
Medical
legal report not received.
Oh, legally is not there,
One
but he is
prescription
saying that
that
one
is-
prescription.
That is outdoor patient as a outdoor patient.
as an
Where is, you have take this one? Flag this one? What this one? Outdoor?
And on the top of the it is outdoor patient sleep also.
as per my
You
instruction.
don't know whether he had given any advice for his eye treatment on anything.
That is not there.
How can we say no, cannot say anything?
Let the medically.
My instruction is this, that the informant was carrying a sword. An informant was short in height and he was little bit tall. So when he attacked, he tried to save himself and that made the injury. And that is why I'm saying that it is
If
not
there
a
is
case
any kind of stories
attack
involved
by
as per the
sword.
statement of the
Not sword,
petitioner
not
or
sword.
Dao or anything. So let the medical report come also.
And the dao has also not been recovered.
But you admit that you were carrying a dao.
No, I was not carrying. The informant was carrying a dao.
So there is
Informant was
there is-
short in, let
Length.
me explain.
Hmm.
Informant was short in height.
Hmm.
He attacked me from behind. When I protected myself, he got injured from his own sword. That is from the dao. Nothing as such. We have not assaulted him.
Then Narsimha can you fix it on any other date also? I will bring the medical report.
Then let it be this Friday, Lordship. My
Friday,
humble request.
Possible also on Monday.
Friday, I don't know. Friday may not possible. May not be, maybe on Tuesday only.
Tuesday.
Monday because
Tuesday,
wedding
I think
ceremony.
Tuesday I have a personal difficulty. I think I will not be available on Tuesday, Lordship. No, let it be on Monday then. Monday is a 21st.
Monday matter may be fixed, but I don't know timing because we have to attend this wedding ceremony of.
Okay,
Chief
oh,
Justice.
yes,
That's why we are not.
Let it be on 24th, Lordship, Thursday.
24th is a Thursday. On 20, but I mean Tuesday you have some problem.
Tuesday I have some problem, Lordship. I will not be there. Tuesday.
So
Wednesday, I
you're
will not
going
be
to
there.
retain the case diary, Mr. Lofgren?
Lordship?
Retaining the case diary, you can call for the medical
I will
legal
retain the
report.
CCTV.
Then let it be on 24th, Lordship.
24th. Heard Mr. A. Bhattacharjee, the learned counsel for the petitioner. And also heard Mr. B. S. Lawford, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Lawford that the case diary received, but the IO has not collected the medical legal report till date. In that context, Mr. Bhattacharjee submitted that the report may be necessary for the disposal of this case. CDB retained till next date of listing, and the additional PP is thereby asked to communicate with the IO to get the medical legal report posted on or before the next date of listing. List accordingly. Okay. CDB retained. CD will be retained. 24/7.
Item number 14 and 15.
14, 15.
Yes.
In the next week, Malad.
Can it be?
In the next week, Malad, 23rd or 24th, Malad.
We have received the case there, madam.
23rd, 24th.
22nd, Malad.
No.
Tuesday, Malad.
Just side of one can fix us.
Tuesday.
তো নাজানো টিউজডে পাৰে যদি চাওঁ নোৱাৰে যদি নালাগে সোয়ারিং মানডে হ'ব চাগে টিউজডে হ'ব নেকি
Tuesday.
আপনি টিউসডে বুলি গম পাইছে নেকি?
22B.
আপনি গম পাইছে? এনে মই শুনা মতে মানডে 21st কোনো মনৰ বাকী। Let it be 23rd or 23rd then?
23rd or 24th, no?
23rd, 24th. 24th হৈ যাবতো পাৰিব ন? কিছুমান দিয়া যেন পাইছো এইকাৰণে সুধিছো।
23rd,
23rd to
23rd.
Yes, let it be 23rd.
Item 14, 15 million.
Item 14.
14, 15 million. Two items.
Both 14 and 15?
Yes.
Yes.
23rd.
Please.
The CD may be written, madam.
Yes, CD be written till next date of listing. We are going to return the case.
Highly obliged, madam.
Okay. Item number 39.
39? 39?
Sorry, 34.
34.
34.
Yes. 34, yes.
Say anticipatory bail application, my lord, in fact, suscited matter, my lord, and LCR was called for, my lord. LCR we have basically.
So you were shown as an absconder there.
Absconder in the charge sheet, my lord. In fact, police doesn't have the authority, my lord, to show me absconder in the charge sheet. That is the settled position of the apex code. That has to be as per the 82 CRPC, my lord. And then your lordship kindly come to page 14 is the FIR, my lord. That is 10 is the FIR, my lord. In fact, this is I am my lord Muhammad Asikul Islam, and my lord
FIR is at page 10.
FIR is page 10. The allegation is that, my lord, from 1 year back, my lord, I'm having this my lord love affairs with the my lord daughter of the informant, my lord, and she got married, my lord, and then she gave birth of a child, my lord, and she, my lord, disclosed the fact that, my lord, in fact, she had the love relation with me, so that my lord, in that way, my lord, I am involved in that case, my lord. So it is admitted that there was some intimacy, my lord, relation, my lord, with me. In fact, my lord, she got married to some other person. Accordingly, my lord, we, my lord, got end with that relation, my lord. So to that effect, my lord, I had the relation, my lord. But so for this, my lord, allegation, my lord, you'll also will kindly come to page 10, my lord. I am reading out, my lord. This is by the informant, her mother, my lord. Respectful, humble prayer of the informant is that for a year back from today. So this is the incident of 1 year back, man. They are, my lord, alleging the above mentioned accused number 1 without my knowledge having illegal affairs. Involved in physical relation with my daughter, namely so and so, got her consent. Although me and family being not there, she was married to some other place. My daughter, having given birth a child before expiry of 1 month of marriage, has been driven out of the husband's house, taking shelter in other place, and her life has become miserable. On being asked to her, only it has come to learn she got conceived through the accused number 1. So this is after more than 1 year. After she got married to somebody else, man. She is disclosing this fact to her father, man. Even, my lord, one child is, my lord, given birth, man. Now, my name is now taken by the informant, my lord. And in fact, my lord, you'll also will kindly come to, my lord, the search sheet at page 14, my lord, where it is disclosed by the officer, my lord, investigating officer, that she refused to go for medical examination, my lord. Page 14 is the, my lord, search sheet, my lord. And here, my lord, I am shown absconder. That is not permissible, my lord. In fact, then your lordship kindly come to page 15, my lord, where this is, my lord, stated by the investigating officer that, my lord, she refused to come, my lord, to the police station to go for medical test, my lord. That, my lord, your lordship will kindly, after paragraph 7, my lord, debrief of the charge sheet.
What will come out in the medical examination? It's okay.
Yes.
Nothing will come out in the medical examination.
In that
What
way
will
also,
come?
in that way also, there will be nothing
She
coming out.
already conceived, gave
Yes.
birth to a child. So
5
nothing
minutes
will come.
Yes, yes.
I have taken that 164 statement.
Even assuming, my lord, she has refused to go for medical test. So that
No use or no purpose of doing
Yes,
for
that-
medical.
that is one aspect of the matter, my lord. And otherwise, she refused to go for medical test. So that, my lord, in that view of the matter,
So have you annexed the order sheets here?
my lord, in fact, my lord, and I have not annexed this, my lord. One order I have annexed, that is my issuing summon, my lord. By the, my lord, your lordship will kindly come to page 20.
Page?
Page 20, my lord.
So only summons were issued.
Yes, my lord. So I am apprehending of errors because, my lord, this 376 to N is, my lord, incorporated, my lord, because it is,
Now see your conduct. Your summons were issued to you on 2022.
yes, yes. I am
But
represented.
since then you are absconding.
Yes, yes. In fact, my lord, I was represented by the, that is, I have stated in my petition also. I was represented by the learned council, my lord, in that court, my lord. In fact, because of some communication gap, my lord, that was, my lord, in fact, that is my fault, my lord. I could not, my lord, have the touch with the court's proceeding, my lord. So in that way, my lord, I could not appear, my lord.
It will do.
And in other way, my lord, 376 to N is, if at all, my lord, attracted. If not a minor girl, but she is having assuming that there was some relation, my lord. She is not a minor, my lord. She is a major girl, my lord. And that too after 1 year, my lord, this is being, my lord, disclosed, my lord. Why she did not just disclose this fact, my lord, earlier, my lord?
See, the court took several steps.
Yes. Wait, yes, yes.
Even the IO was also show cause, in fact, why the NBW was not executed. So several NBW have been taken. In the case record process from state to the
As per 164 statement, there was a physical relation on the.
So lastly, PNR is also issued.
That is why he has priority.
Married, though, we cannot, we're not considering in that way, married now. But the fact is that the initially summons were issued.
Yes. No, this is there were PNA issued lordship, he did not appear before. During the course of investigation, so he was not he did not appear before the IO lordship. He was absconding himself lordship. So lordship, this is his.
In fact, that is not absconding, my lord.
Maybe that word may not be also absconding, but he was not cooperating with the investigation. He was evading lordship.
Not evading, in fact, my lord. There was some, my lord, communication gap. I have stated in my petition, my lord. And he's a daily wages labor, my lord. He uses to, my lord, do walks in other places, my lord. So in that way, my lord, she, my lord, could not appear in the case. In other words, my lord, 376 and 2 doesn't have that. There was having some, my lord, intimacy, my lord, between them, my lord. And if any physical relation is there, that is, my lord, consenting.
That is the solicited sections process. The court will learn it and trial court will see what section is to be added lordship or what section under what section in the cognizance is to be taken lordship. Because as he is not appearing today, the case is.
I will appear, my lord. I will face the trial, my lord. There is no doubt.
Heard Mr. J.C. Bora, the learned counsel for the petition, and also heard Mr. B.S. Locker, the learned additional PP appearing on behalf of state respondent. This is an application under section so-and-so in connection with so-and-so. Scanned copy of the TCR has already been received. Barrister series. It is submitted by Mr. Bora, the learned counsel for the petitioner, that the present accused petitioner is innocent and he is no way connected in the alleged offense. From the FIR, contents of the FIR itself, it is seen that it was lost only after her marriage and after giving birth a child by the victim. There was no other earlier no FIR was lost against the present petitioner, and the FIR was lost only after her marriage of the victim when she was driven out from the house of her driven out from her matrimonial house. Full stop. Further, he submitted that the accused person is a daily wage labor, and for earning his livelihood, he had to leave for his place of residence. And though earlier the summons was issued to him, he engaged an advocate to represent him, but due to communication gap with his counsel, he was not aware about the issuance of NBWA against him. Further, he submitted that the investigating officer has no authority to shown him as absconder in the charge sheet, and without any further inquiry, and so. However, he submitted that the court earlier issued the summons against the present petitioner. Full stop. He is ready and willing to appear before the learned trial court below and to face the trial if he is granted with some interim protection. Full stop. Next para, Mr. Lockhart, the learned additional BP, submitted in this regard that there are sufficient materials against the present accused petitioner, and from the case record, it reveals that the accused was avoiding the police arrest, and the summons could not be served on him. Avoiding the police arrest, and in spite of issuance of NBWA on several occasions, he could not be arrested in connection with this case. And thereafter, considering the report of the IO, a report of the executing officer, the present accused petitioner, the PNA was issued against the present accused petitioner. Mr. Lockhart accordingly submitted that considering the conduct of the accused petitioner, the prayer for anticipatory bail cannot be granted at this stage. Full stop. However, he may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. Next part. Hearing this submission made by learned counsel for both sides, I have also perused the case record of PRC number 834/2022. So till now, the case could not committed.
Yes, because he's
Yes, and the order, and specifically the order passed by the order passed by the learned trial court below. It reveals that initially the summons were issued to the accused petitioner after receiving the charge sheet, but in spite of service of summons to the present petitioner, he did not appear before the learned trial court below, and hence finding no other alternative, the NBWA had to be issued against him. It appears that the learned trial court below took all endeavors to procure the attendance of the accused petitioner, but in spite of his endeavors to procure, but the accused could not be arrested, and the NBW could not be executed on the petitioner. Full stop. Considering this aspect of the case, the learned trial court below also issue reminder and the show cause to the concerned to the OC of the concerned police station, and subsequently finding no other alternative, the PNA had to be issued on the present petitioner. Thus, it is seen that since 2022, the accused is avoiding the police arrest and not appearing before the learned trial court below. Considering entire aspects of the case as well as the conduct of the accused petitioner, I don't find it a fit case to grant any sort of interim protection to the accused petitioner. However, he can approach the learned trial court below and with an appropriate application for bail, which may be considered in accordance with the above observation. Give source and disposal.
My lord, may I pray for, my lord, since no offense committed, my lord, no coercive action shall be, my lord, taken, my lord. No coercive action shall be taken.
course, this action has to be taken. You are avoiding it since 2022 and I have seen very, the order was passed, even show cause was issued to the OC. Reminder was issued to the OC on 3-4 occasions, then only VNA was it. So every endeavor has been taken by the London Transport Bureau. We are not in a position to grant you any sort of interim protection.
My lord, that is because of some communication gap. I have
Whatever,
stated in my
whatever,
mail.
we are not.
I'm deeply aware.
45.
We have not received CD receipt.
CD receipt? Not received. Are you on interim there?
No.
You are not on interim. When it can be called for?
Sutia.
Where from it has to come? Sotia.
Sutia. Sutia, no?
CD was called on 19/6/25. It's already 1 month. So matter may be listed on 22 month.
21 and 22, I don't know, there may be some problem. In fact,
Then next
court
week,
may
any day,
rise a bit.
next week, any day.
On 25th, yes, 25th.
20?
Five.
25. Okay. List on 25. Issue reminder, list on 25. We're listing it on 25.
Deeply obliged. Item 56.
Yeah, please, Lordship. Lordship, sir, for equity application, my lord. The FIR is just 10
Whole
months.
meeting
My lord,
is
here
up.
we have received the case there.
এটা তো সব মিটিং আছে এটা লাইন বলে দেখা একটু ঘুরে টলো anyway, yes,
For sure. FIR is just 10 months.
you have received the case diary here.
My lord, I have received the case there.
FIR is at page.
Read, my lord.
Yes.
Sir, with due respect, I beg to state that on 12/5/2025, in the afternoon about 2:30 p.m., the above mentioned accused person were plucking betel nut from our garden and my mother asked not to pluck the same, as the land is under dispute and the case is ongoing over the said plot of land. And that she objected to their action. Upon being confronted, the accused person became violent and physically assaulted my mother, Pranita Sarkar, wife Resharani Sarkar, and younger brother Sandan Sarkar, using wooden stick, dowel and rods. The above incident took place in the premises of my residence. As a result, the sustained injuries and were initially taken to the Bhatagaon SDCH Vizni, however, for advanced medical treatment. They were referred to the Lower Assam Hospital, Boingo, Assam. The accused person took one gold chain belonging to my mother, one Vivo mobile handset belonging to my young brother, and gold bangles belonging to my wife. This is the case matter. The fact is that, yes, my lord, I have stated in paragraph number 6, Lordship, kindly see page 4, my lord. Page 4, my lord.
Page 4.
4. Paragraph number 6, my lord. That the fact of the case is that on 12/5/2025, the accused petition number 1 went to pluck betel nut from his garden, but the complainant, namely Pankaj Sarkar, his mother Pranita Sarkar, his wife Rekharani Sarkar, and his younger brother Sandan Sarkar, jointly ferociously created violence upon the Brajnath Bishwas, new petition number 1, and assaulted him and roped tightly with a betel nut tree in his garden, and also beaten up by bamboo sticks. After spreading this news, other accused petitioner reached at the place of occurrence to save the life of the petition number 1, my lord. When the other accused petitioner trying to rescue Brajnath Bishwas, that is accused number 1, my lord, from the hand of the complainant side, there is a scuffling between the parties. As a result, both the parties are simply injured due to pushing and shoving. The petitioner never assaulted nor took any ornaments to as well as mobile phone else in the other matter.
Okay, yes, sir.
That's it. Lordship.
I have page there.
Lordship, kindly see page number 23, ma'am.
I don't have time, huh?
No.
It will be part heard otherwise because we have a meeting at 1:15.
Page number 23, my lord.
23,
my lord.
Huh.
The picture, my lord. The petitioner number 1, my lord, this is accused number 1. He was been roped by the informant, my lord. Lordship, kindly see with the betel nut tree, my lord. And as a result, the petition number 1 also filed, my lord, complaint, my lord, and except for my lord.
It was registered or not?
It is registered, this case. Before the SDGM at Disney.
Miss case? What kind of miss case?
Under section 126 and 127, 137.
That means it's a complaint case.
Complaint.
It's already registered.
already registered, my lord.
So you have lodged a complaint.
Lordship, we have also filed an FIR before my lordship, one Panbari, yes, my lord, but the jurisdiction is not there, my lord. That is why they have returned my FIR, my lord.
My lord,
Yeah.
we have received the case there, my lord. It is true that there is a land dispute between the and this case is also going on in the land, my lord, where it was there, my lord. Incident took place, my lord. Here, Lordship may kindly pay us the medical report, my lord, injured.
The simple injury.
No, simple injury not there. Lordship may kindly pay us. Here are 3 injured person, my lord. Rakhamani Sarkar, Sandon Sarkar, and Punita Sarkar, my
In
lord.
the FIR, my lord, the case has been registered, my lord, all are simple injury, my lord. And all are available, my lord. 329(3), 1152,
There are
1172, my lord. All
medical
available, my lord.
report is there regarding Sandon Sarkar and Punita Sarkar, my lord. Lordship may kindly say there, my lord. Fracture is also there, my lord, and grievous. Some of the injury are grievous, some are simple, my lord. And both the, my lord, Pranita and Sandon Sarkar, my lord. And their statements are also there, my lord, how all of them assaulted the lady, my lord. That is Punita Sarkar, 56 years old, my lord. And Sandon Sarkar, my lord. All of them beaten, my lord, brutally, my lord. Fracture is there, my lord, and medical report, it is clear, my lord. I have another witness, my lord, June Sarkar. He is the minor, my lord. When she has taken the mobile phone, my lord, one of the accused person has taken the mobile phone also. Her statement is also there, my lord. I have checked, my lord.
Recovered or not?
June Sarkar. Minor girl.
No mobile phone has been recovered from our possession, my lord, till today, my lord.
You are not arrested.
No.
You are not arrested. That's why it was not recovered.
And all of the sections are involved in this FIR, my lord, or bailable section, my lord. Except 308, my lord, one.
What is 308?
Extortion, my lord.
Otherwise available, not grievous section.
All available.
No, the sections because they sustain, it seems that this some of them sustain grievous. Grievous.
325.
Huh?
323 and 325.
Available.
So
Original.
that's why. Okay.
And 308 was extortion, my lord. But injuries are there, my lord. I have seen in the medical report also, my lord. A fracture is also there, my lord. 2, 3 injury are grievous, my lord, and 1, 2 are simple. Sandon Sarkar, Punita Sarkar.
Have arises, my lord, and I have still stated before you, my lord, and also the photographer is also there, my lord. The petition number 1 has been broke.
That is there. It is okay. That is land
The
dispute.
moral policing is there, my lord, by the
But
informant.
that, how it was brutally assaulted, my lord. That is also one of the fact, my lord. And Lordship may kindly
We
pay the
have-
June
we
Sarkar,
have-
statement
we
of the
have-
June,
we have
my
tried
lord.
June Sarkar I have seen.
My lord.
We have typed that by the informant, my lord, with a betel nut tree, my
Why
lord.
you are going to collect the battle? There is a
This
land
is
dispute.
my garden. There is,
Land dispute, it is clear.
I have stated also that there is a land dispute between the parties.
Case is also going on.
I'll pass the order. Okay, I don't have time, I'll pass the order. একটু হেঁটে হেঁটে দিয়ে দিব স্যার চেম্বার if it's possible I'll just give it now.
No.
Finding item number 42.
Probably appropriate person. Yeah, it should be
My lord,
appropriate.
yeah, my lord,
batch.
my lord.
Lordship already lordship 59 days, lordship behind the bar, lordship.
This is
Can be granted
regarding
bail,
NDPS
lordship.
matter, lordship. So it will go to appropriate bench, lordship.
Tomorrow only?
Appropriate bench, lordship.
Appropriate bench list tomorrow, we're passing the order. List before, list before appropriate bench? List before appropriate bench on tomorrow is? Huh?
Notification দেখাই দিয়ক, ওটা লৈ ল'ব। মই এইমাত্ৰ ready কৰি দিম।
মোৰতো নোৱাৰে। We have an information, just Justice Kalita is over with the records, I mean, the cases. tomorrow may not be possible on his part also. Then at this Monday,
The 60 days of our lordship. Today's 59 days.
and you can otherwise you can withdraw this one. What to do? I'm not dealing with this special, no? That's why.
He could mention it, lordship.
Pardon?
Tomorrow, if he could mention it, lordship, then also it may be sent to any other bench, lordship, by today itself, lordship. But he
It's
didn't mention
tomorrow,
it.
lordship.
Okay, we're listing it tomorrow because
Tomorrow.
it's 59 days, this tomorrow. Before the appropriate bench. Tomorrow mean, tomorrow that is on 17th, so and so. 17th is not, 17th. 17th, so and so, before the appropriate bench. CD, we received the CD here. CD be retained till next date of list.
Item number 9.
9, item number 9, yes.
It is 160 days behind the bar. Yes, out of 2 exits, one has granted bail, a customer one from whose possession it was recovered. And says, I am the driver who hired my vehicle and your lordship granted bail on the ground of that notice. In 90 days, 91 days, he was released on bail. Today I am 160 days. Consider that in sort of parity also applicable and 160 days behind the consider that detention period. He admitted I am driver and he is the owner of the goods already released on bail. Customer 1 and the customer 2.
You have next the order here?
Lordship, I annex. Page 20 is the order and the given portion is 26 paragraph 12.
Yes, what?
Otherwise, only because co-accused on some other grounds, your lordship has granted bail, but parity cannot be a ground for considering the bail application of the present petitioner, because your lordship may kindly page 21. Earlier order passed by your lordship, my lord. Paragraph 3. It is submitted by so and so and a senior counsel for the petitioner that the present accused petitioner is no way connected with the alleged offense. He was arrested only because the vehicle which was alleged to be loaded with contraband was parked in front of his house. He is also not connected with the other co-accused persons and he is resident of other place. That is the, my lord, submission at that point of time. But here, my lord, the present petitioner from his possession, my lord, those contrabands were recovered. And my lord, the petitioner was caught red-handed. And at that point of time, my lord, other co-accused was also present with him, my lord, as a co-passenger. And now, my lord, regarding after arresting of the petitioner on 2 occasions, your lordship, on 21/9 and 26/5 and 31/2005, he has approached before the trial court and filed, my lord, bail application there.
Then 21, 21, 21/9.
29/1.
29/1.
And my lord,
I have annexed this order. Rejection I have annexed.
29/1/2005 and my lord thereafter on 26/5/2025.
Can you complete FIR, your lordship? I am X number 2. FIR, page 12, page 13 is the accused name of the accused. Accused number 1, Mannan, and accused number 2, it is present petition Shakinur. And petition Shakinur is the FIR itself, page 12, I am the driver. The vehicle was driven by one person named Shakinur. And he purchased the vehicle, hired the vehicle. And he was released on 90 days. I 160, can consider that beyond those 160 days. It's not. Instead of 80 of that is our enough time has had the investigation to examine 160 days.
Where is rejection order you have annexed?
I have annexed yours.
Annexed order.
Page 17 years.
17.
17. For 2 months back, 26, 5 your lordship.
Yes, whatever, any assumption.
My lord, record itself, it reflects that earlier, my lord, all remedial measures were taken by the, my lord, and he has approached before the trial court at that point of time, no point of time, he has raised all these grounds. And it is not that he is not within, all these facts are not within the knowledge of the petitioner, my lord. He is fully aware about all the, and from him, my lord, he was caught red-handed at that point of time. So, my lord, at this point of time, my prayer before lordship, these grounds will not help.
Case is not yet charged sheeted.
Not yet charged sheeted.
Also 160 days. That's enough. If it's not one release or 90 days, 91 days.
Morning hours, almost you, someone had told me one, referring one judgment of Sakit or who was referring to the judgment?
Regarding knowledge is sufficient. Then your lordship may kindly fix it day after tomorrow.
No, someone was, Mr. Bothakur Sharma or Lokar, I just forgot, in the morning hours. Yes. You have the judgment with you? If you can give me the citation only, then also we can. Do you have the citation with you now? No.
Right now, I can pick it from our office.
From office? Then you just give us. Okay, I'll pass the order.
Sure. Obliged.
সেইটো আহিছিলে ন চিটিটো আহিছিলে No, primary four passes. CD is there, na?
Yes, CD.
CD to logo, going to graduation. Okay, CD.
Obliged.
Was called for last occasion.
CD we have not discussed.
38 CD.
Not discussed.
Are you on entry? No. When it can be fixed?
Shorted kindly because it was so long date earlier.
On 20 feet or
Long date earlier means?
Means well, it was.
Acha.
Yeah.
on
Not
29.
long date.
29.
29 of this month. CD not received. Issue reminder 29/7. Okay, we're listing it on 20.
I am glad.
39 also we have not received CD.
May please your lordship. CD was called for in this case. Yes, there was called for.
We have not received those.
Look, I'm not.
Here also you are on interim? No.
No. Short date we will given.
Short date as such.
Sotia PS.
From where it has to come?
Sotia.
Huh?
Sotia PS.
Sotia.
Yes.
29 or
29. Okay.
Nice.
29.
Alright.
Same order.
Okay. This is an application under section 482 of PNS also.
Here also we have received the case diary. We have received it.
Petitioner is not on interim,
He was on interim?
Not on interim.
Not on interim.
He is 12 euros.
Case 12.
With the FR.
Yes.
With due respect, I beg to inform you that once Srimati Jinti Boragohai Chutia Bank Program Surgery, along with Dr. Dimbeswar Shutia and the employees of Domain Vikas Bank, the more branches have been jointly misapplied a huge amount of money below notice 7 years, providing fake deposit slip without depositing the amount in the bank. This is the allegation. Your lordship will get the money that is allegedly misappropriated.
Page
at
13.
Page 13. Now, your lordship,
Jinti Buragohai Sutia is a bank metro and my wife, your worship. As such, I don't have anything to do with this, either with the bank or with these self-help groups, your worship. In fact, your worship, when they first lost the FIR, my name was.
No, you are,
I am Dimbeswar Sutia, your worship.
so Dimpy, Jinti is your wife.
Jinti is my wife, and that's probably my fault, your lordship. And your lordship knows very well, your lordship, these bank metros are for assisting the customers in opening the bank accounts, your lordship. More than that, they have no role, your lordship. Even otherwise, if she has any role, your lordship.
So, Jinti Buragohai, he is in the working as a this
Bank
mitra,
metro,
bank mitra.
bank metro.
And you are?
I am her husband, your lordship.
You are her.
My husband, your lordship.
He is not, no.
He is not an
Not an employee. And in fact, she was, your lordship, granted interim bail by this honorable court, your lordship. And your lordship, thereafter what happened, your lordship? They have issued a 35-3 notice, your lordship, that your lordship will get it at page 19.
Page
19. Apparently, your lordship, 35-3, since it says, your lordship, arrest is not required only, then this is issued, your lordship. And secondly,
So
your lordship,
responding to 35-3, have you appeared?
no, your lordship, we have not. I came straight away to this honorable court, your lordship, on receipt of this. And since it was not, interim was not considered, your lordship, on that date, and a short date, this matter is fixed, we did not appear and inform them accordingly, your lordship. And your lordship will kindly see the sections under which this was registered 61-2, 3184, 3165, and that your lordship, criminal breach of trust by a public person servant, that probably I will not be attracted, your lordship. And so far as the other cheating is concerned, 7 years of bail, your lordship. Ultimately, even going by the law laid down by the apex court in those cases, Ernest Kumar and subsequent cases, your lordship, I am only entitled to 35-3, but I am apprehensive since, your lordship, this criminal breach of trust by public servant is there, which is, your lordship, life, your lordship. That's why I am.
Which is this section? Criminal breach of is
3165.
3165.
.409, your lordship. In previous incarnation, your lordship, 409. So therefore, I am before this honorable court. Even otherwise, your lordship, suppose, your lordship, they have given me some money, your lordship, that they cannot ask me to deposit money on their behalf, your lordship. That cannot be. Neither I am a bank mitra nor I have anything to do, even assuming they have. That is their own fault. But my submission is that, your lordship, I have not handled any money. What my wife has done, your lordship, that will be revealed from the case there, your lordship. So far as my case is concerned, your lordship, I am first of all, your lordship, my arrest and is probably not required in this case, since I am not handling the money. Secondly, 409 will not be affected against me. And thirdly, they themselves says 35-3 notice, by issuing 35-3 notice, that my arrest is not required, your lordship. These are the grounds on which, and my wife on the same ground, your lordship, the 35-3 notice has been issued, so granted interim protection by this honorable. This is my humble submission. Your lordship will go to the case there, your lordship.
Yes. As per CD lordship, the main prime accused is lordship Jinti Buragohai, and her husband is Dimbeswar Buragohai. This, but some of the witnesses have stated, lordship, that they have handed over the money to Jinti Buragohai as well as Dimbeswar Buragohai. That must materials are there also. By how, that is not mentioned, but the line is also there. 22 আজি 22 শ্ৰীমতী জিন্তি বুঢ়াগোহাঁই চুতীয়াৰ লগতে তেওঁৰ হাজবেণ্ড ডিম্বেশ্বৰ বৰচুতীয়াৰ হাতত আৰু কেতিয়াবা বেংকৰ কেচিয়াৰ শ্ৰী ভাৰ্গৱ গগৈৰ হাতত জমা দিওঁ. That is the same line.
And if, your lordship, they are giving me and I am handing over to my wife to do that, and if she is not depositing, how can I be held responsible for that, your lordship?
You are the husband.
That cannot be, your lordship. I have an independent existence ultimately, your lordship, as an individual. If I am somehow connected with the bank, then matter would have been different, Your Lordship. So far as I am concerned, I have, in spite of the fact that we are husband and wife, I have independent existence. She has independent existence.
Why he
So
has taken
simply by being a husband, Your Lordship cannot be, and that also Your Lordship has in Your Lordship, there's a vague statement that sometimes, Your Lordship, when, how, ultimately to even to file a search sheet against me and to give me punishment in trial, they will have to come up with very specific things, Your Lordship. In absence of that, Your Lordship, probably and ultimately, Your Lordship, everything will be determined once the documents are seized, Your Lordship. Probably custodial interrogation of petitioner is not required. This is my humble submission, Your Lordship.
Heard Mr. S. Waterford, the learned counsel for the petition. And also heard Mr. B.S. Lockwood, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so, connection with so and so. CD receipt, parents receipt. Is submitted by Mr. Waterford that the present accused petitioner is no way connected in the arrest office. His name is shown in the FIR only because he is the husband of the accused number 1, Srimati Jinti Buragunai, who is a bank employee and working as a bank mitra of Brahmin Vikas Bank, Demo, Chariali branch. As he is not an employee of the bank or the government employee, the sections 1065 BNSS does not attract against the present petitioner. Further, he submitted that and a 135(3) notice was issued to him, asking him to appear before the learned trial court below. But as the case is also registered under section 3165 of BNSS, he had the apprehension of being arrested in connection with this case, and for which only he approached this court with the present application seeking for anticipatory bail. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of the arrest bail. Mr. Waterford further submitted that the purpose of issuing notice under section 135(3) BNSS, it itself reveals that the arrest may not be required for the present accused persons. Next, madam, Mr. Sharma Lockwood, the learned additional PP, submitted in this regard that as per the materials from the materials available in the case diary, it is seen that the present petitioner is also involved in the alleged offense, and some of the customers also used to deposit money in his hand to be deposited in the bank, which are to be deposited in the bank. Further, he submitted that it is a fact that the present accused petitioner is not a bank employee or other office employee, but in connivance with his wife, he had misappropriated the money. Next paragraph. Considering the submission made by learned counsel for both sides, I have also perused the case diary and from the materials available in the case diary and other aspects of the case matter, I find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner with a direction to appear before the IO and to cooperate in the investigation as and when his cooperation will be needed. By condition Gisman Diri. Okay, we will continue. Deeply open. Deeply open.
Item number 43.
This is the last.
Matrimonial dispute, my lord. Husband and mother-in-law is the petitioner before your lordship, my lord. Husband and mother-in-law is before your lordship, my lord.
Now, my lord, on last occasion, the court was, when the matter was posted before the court, my lord. A scan copy was called for, my lord, to ascertain whether is regarding injury, my lord. Page 12 is the injury part, my lord, of the scan copy, my lord. Which shows that, my lord, is
Page 12.
12 scan.
Only to ascertain injury.
My lord, that
This is
was-
a charge sheeted case.
And whether the petitioner is participating in the proceeding before the trial court, my lord. Whether there is any long gap in his appearance, my lord. But that order sheet was called for, my lord, which shows that, my lord, on only one occasion they took time, the adjournment petition is there, my lord.
I don't know, you were shown absconder or you were participating in the trial?
Absconder, my lord, subsequently someone issued by the trial court, my lord, by the learned CJM, my lord. And-
Here I have gone to the scan copy matter. Here both the accused person submitted against them charge sheet submitted matter, showing them as absconder matter. Here the notice was issued matter to appear before the, and that is fixed for appearance matter. Appearance matter.
Till now, only summons were issued.
Summons were issued matter. Then I have gone to the record also matter. There is a dispute regarding husband and wife matter. And statements are available in the IF flag mark in matter. And the injury report regarding the injury report matter.
Page 12, ma'am.
Her injury is simple injury caused by blunt object.
It's okay, we are not going by the such merit of the case now at present.
Mine.
So, but the, as per the conduct of the accused, they were shown as an absconder.
Mine. In the charge sheet.
These two are only accused persons in the case or other?
Only.
One is husband and one is mother.
Where is the order sheets? These are.
In the scan copy.
One is husband and mother-in-law.
So on your behalf, some petitions were filed.
Mal, only for one
Those
occasion.
were allowed.
All.
Only for?
On one occasion, my lord, they took time for appearance, my lord. Adjournment was served, my lord.
So you, earlier you approached the learned session just for
Session
clearance.
rejected, my lord. It is
That
there.
was rejected.
Rejected, my lord. Starts from page 19 onwards, my lord. Now, only apprehension is that, my lord, the section 307 is there, my lord, which is exclusively traveled by the learned, by the court of session, my lord. So, and the matter is fixed before the CJM, my lord. So, petitioner apprehends that in the event they appear before the learned CJM, my lord, they would be had the bar.
So as per the injury report, what are the injuries?
Simple injury.
Simple injury.
Caused by blunt object.
No, now see, 34307 simple injury may be there, but what is the vital part and all that is to be seen.
Injury. Some injuries are there.
Elbow joints, left arm, left toe. So from these injuries, there cannot be any such inference of 307. Obviously. Had Mr. J. Lashkar.
My lord.
Had Mr. J. Lashkar, the learned counsel for the petitioner. And also had Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Scan copy of the TCR has already been received. Where is the same? It is submitted by Mr. Lashkar that the both the accused petitioners are innocent and they have not committed any such offense as well as in the FIR. Though the case is registered under section 307, not 307, BNSS?
No, IPC.
IPC.
498A, 307.
34.
Though the case is registered under section 498A, oblique 307, oblique 34 IPC, but from the injury report itself, it reveals that there cannot be a case under section 307 IPC. Why didn't you cooperate in the investigation? Is there any explanation from your side?
All along I was there, my lord.
Huh?
All along the petitioners are there, my lord. And I have.
You
taken-
never, you were never searched by police.
Never, sir, my lord. And my specific government is there.
If it is submitted that, Mr. Daskar further submitted that, both the petitioners were already, always there in their own residence, but they were never searched by police during investigation, and hence they were not aware about any, not aware about the pendency of this case or lodging of FIR by the informant of the victim. However, they are ready and willing to contest the case by appearing before the learned trial court below, as and when the date to be fixed, if some interim protection is provided to them. Next para, Mr. Sharma, the learned additional PP submitted in this regard that from the injury report, it is seen that the injuries sustained by the victim are simple in nature, but there are other incriminating materials against the present accused petitioner, and they were not cooperating the IO during the investigation, and for which both the petitioner were shown as an absconder in the charge sheet. Accordingly, he submitted that there may not be any interim protection for the petitioners, however, they may be directed to appear before the learned trial court below with an appropriate application for bail. Next para. Considering the submission made by learned counsel for process, I have also perused the scanned copy of the TCR and the especially the order sheets. It reveals that both the accused petitioners were shown as an absconder in the charge sheet, and after filing of the charge sheet, the summons were issued to both the petitioners, and the petitions filed on their behalf is also considered by the learned trial court below. However, as the case is registered under Section 307 IPC, the petitioners have the apprehension of arrest in connection with this case, and hence the present petition has been filed. Oh, no. Last रुपएगा तो कर सकूं. The case बाकी नहीं काटी जाए. Considering the materials available in the case record and the order sheets and the orders passed by the learned trial court below, I find that some interim protection may be provided to the present accused petitioners, and accordingly, petitioners with a direction to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. When the next date is fixed, your 23/7. 20 person everybody so and so, and till their appearance on the next date of listing, next date before the learned trial court below, no corrosive action shall be taken against the petitions, and their bail petitions may be considered by the learned trial court below in accordance with law.
Now, my lord, already session just rejected my bail petition, my lord. Already session just rejected my bail petition, my lord. My lord, better.
No, this is not the, it's committed already, not committed.
The session, I have approached learned session judge by filing an anticipatory bail.
No, I'm not on session judge.
That was rejected, my lord. And now,
That's what I'm saying. Your petition by session judge is rejected.
My lord.
So I have made some observation here, because it's showing you as an absconder, whatever. So made some observation here, and no corrosive action shall be taken against you. With this observation, you appear before the learned trial court below with a fresh application for bail. If that is not considered, then only you come. Otherwise,
I put behind the bar, ma'am.
That I don't know. Let's see what happens.
Right.
dispose কৰি দিম। Tomorrow actually off কৰি দিবচোন।